Yes. For misappropriation of rupees 57,692.
Yes.
My lords, the accused opposite party, my lords, actually was entrusted with fertilizer and committed criminal breach of trust. In respect of that said fertilizers amounting rupees 57,692. Against that order of acquittal, my lords, the state has preferred this petition seeking leave of a lordship honor's court, my lords, in 2011. And the exact findings, my lords, are the grounds you have taken.
Mr. Das, I don't go to the grounds because I understand grounds maybe directly on the point or maybe something because a lawyer is drafting, so he has to put some grounds. I have to see that first in the
exact findings, whether it's to suffer from the vice of perversity or not.
Yes.
The Lord should turn to
which particular finding?
Have
you seen that?
Exactly.
You have the copies of the depositions. So you obtain if you want to.
In fact, I'm afraid, my lords, even if I'm being empowered with provided with this kind of evidence and all these things, to find out the contradictions or to indicate any amount of perversity, my lord, will be a stupendous tax for me, my lords. Lords, we turn to the findings, my lords, at page 13 of the running code.
Finding you are agreed. But which evidence, which PW statement or evidence the court could have
could have been acted upon.
Acted upon or taken a different view. Even in case of acquittal, different view is not also admissible.
In fact, the evidence of 16 lends supports to the case of the defense, my lords. Page 13. In fact, prosecution relied on PW 8, 10, 13, 15, 16, 17. But
page 11, dekhantu.
Yes.
Page 11, internal page 11 of the judgment.
My lords. Analyzing the evidence of PW 8, 10.
Above that.
In reply, defense counsel.
Yes, because PW, your contention has been noted at the top of the paragraph, relying on the evidence of PW's.
8, 10, 13, 4, and 15. It is seen that all the witnesses stated in clear term that Nandalal Purohit, president of that.
I'm not reading that. Relying on the evidence of PW
8, 10, 13, and 15.
The Lorette Special PP Vigilance submitted that. Kindly read that. Yes, continue reading.
All the witnesses deposed in clear term that they have not signed in receipt book.
Stop there. So according to you, is it a correct finding or not?
But that is contrary to PW 16. The PW
8, 10, 13, 15. How can I look into 16?
Yes.
If I go through PW 8, 10, 13, 15, suppose you go through, can you say that the finding is...
PW 16 said that 16, it is clear that he did not...
16 is irrelevant because of 8, 10, 13, 15 and they have been examined ahead of that.
Right.
So whether PW 8, 10, 13 have said that in clear that they have not signed the receipt book. Okay. But that is in favor of the... Anyway, they read further. He further submitted that.
He further submitted the accused being the secretary of the Service Cooperative Society first the signature of Lonely PW 8, 10, 13 and 15 and prosecution successfully proved the offense under section 468 IPC through oral evidence of these
Can a signature be proved by oral evidence? By the prosecution? Forging of signature.
Because rather the materials that PW 5...
Mr. Das, kindly listen. You present a witness that 8, 10, 13, 15 did not sign the register. It has been forged.
Right.
Orally.
Right.
Orally, can you prove that?
No, that has to be supported by materials.
Orally, somebody denying the signature cannot be a subject matter of scrutiny by the court. Did you examine the specimen signature, the expert? Who is the expert? What is his version?
No, Exhibit 12 is there. Sheet containing specimen signature of Padmavati Meher. Then Exhibit 14 is that
where is
signature.
PW? Which PW?
Raghunath Meher, Padmavati Meher, Lokanath Meher. PW's number. Yes, PW numbers are.
PW 13.
PW 13.
Padmavati 13. Lokanatha 15.
Raghunath is
Lokanatha or Raghunatha?
Minus.
Raghunatha 8.
8. 13. Entrustment is that, but regarding the factum of forgery, my lords.
That is your case, not the factum of forgery. You say that
dishonestly and fraudulently.
Then kindly read further. So that is your summation.
My lords.
Successfully proved through oral testimony.
Right.
Yes. How the oral testimony it can be proved? The author of the signature will say that I have not signed.
Right.
But if it is there, then you have to disprove it. It is not his signature. Then kindly read the success of para. That is also important.
Page 15.
No. You have missed the page perhaps. You are at page 11. 11 first para. Just now you read the sub para.
Prosecution case.
But running page, there is no marking. It's only 86. My brief is showing 86. But it is 11. Internal page 11 of the judgment.
Minors. Should I start from para 2 minutes?
Sub para. There is no para 2. Sub para. In reply, the Law and Defense Council.
To the Law and Defense Council submitted that all the loanees examined on behalf of the prosecution in clear terms deposed that Nandalal Purohit, president of SCS and peon of the society, namely Upendra, had taken active part in taking signature of the loanees in the register and forms, and none of the witnesses have whispered a single word about the involvement of the accused in loan transactions. Hence, no liability under Section 460 types can be saddled with the accused. That's the defense claim.
Kindly read further.
Analyzing the evidence of PW 8, 10, 13, and 15, it is seen that all the witnesses stated in clear terms that Nandalal Purohit, president of the SSA, requested them to avail loan, and the peon of society, namely Nandendra, took signature in some register and forms, and the entire statements revolves around Nandalal Purohit and Upendra, so far as taking signature in register and form are concerned.
So 8, 10, 13, 15, assuming there is a signature, somebody has forged the signature of 8, 10, 13, 15. They say the signatures were taken by one Nandalal Purohit and Upendra. But here all are accused, or only Surendra Prasad Kaura is the opposite party?
Surendra Prasad Kaura is the...
Then they don't name even Surendra Prasad Kaura. Assuming that, and they state that our signatures were taken. It's not forced.
Taken.
Then kindly analyzing the evidence. Then the conclusion of the court.
Analyzing should I read that one?
Please.
Analyzing the evidence of PW 8, 10, 13, and 15, it is seen that all the witnesses stated in clear terms that Nandalal Purohit, president of SSC, requested them to have a loan. I read that one.
Yes. So where do you find this Rajendra?
No, Upendra.
No. Surendra.
No, the Surendra name is not there.
Surendra the accused, na? Upendra Korele. Upendra is not an accused.
Even accepting Nandalal and
Hon'Ble Upendra, Jadi, upon PW 8, 10, 13, 15 ko grahana korchanti.
Accused Surendra's complicity. So, with
For signature no.
Signature not taken.
For signature no. Nandalal Purohit and Upendra to prove that the accused obtained made for signature in the receipts of 8, 10, 13, 15. Again, if you come back to the top paragraph, then you can easily correlate. He further submitted that the accused being the secretary of the Service Cooperative Society forced the signature of loanees PW 8, 10, 13, 15. Again, 8, 10, 13, 15. Third paragraph. Upendra took their signatures in some register and forms in their entire statement revolves around Nandalal and Upendra. So both ways it is, it doesn't withstand judicial scrutiny. Then Lord Special Public Prosecutor Vigilance during the course of argument tried to impress upon this court by making an alternative argument to the effect that all the witnesses denied their signature in the receipt book and examiner on questionable document. That's not question document. Examiner of questionable documents also opined that signatures appearing in receipt book do not tally with their specimen signatures. And advancing this argument submitted that since the witnesses denied their signature in receipt book and report of questionable document, report of the questionable document also support the testimony of witnesses, it is clear that the accused being the secretary for the signature of PW 8, 10, 13 and 15. Then you just, in view of such challenge, it is imperative upon this court to the evidence of IO, PW 16, who took the specimen signatures of
minors,
the loanees, 8, 10, 13, 15. Just kindly read further.
About PW 16 at page 13, he has
12. You have missed 12.
16.
12. It's not 13. In view of such challenge, pile, page 11 last line pile. Paunanti.
12, page 12.
Page 11 last line. In view of such challenge, pile.
In view of such challenge, imperative upon this court to the evidence of IO, PW 16.
Maybe refer to the evidence.
To the specimen signatures of loanee, PW 8, 10, 13, 15, and send the same to the examiner. And the evidence of examiner question document, PW 17, who examined the same. It is the evidence of PW 15 that he took specimen signature of Raghunath Meher, Padmavati Meher, Loknath Meher, and Surendra Jhankar, and sent the specimen signatures of the above named loanees along the question documents, that's loan disbursement form, to the government examiner. Question documents, Vigilance Directorate, Orissa Cuttack. It is evidence. It is the evidence of PW 17 on 5/6/2006. He received 27 sheet of documents and one receipt book in connection to Sambalpur Vigilance Base and so and so. And on 26/6/2006, he received one loan register in connection to this case, and as per direction of the AIG Vigilance, he examined the documents in original. It deposed that during his examination, he marked the disputed signature purported to be of Surendra Jhankar appearing in receipt book, right, receipt number so and so. Signature Loknath Meher appearing in receipt book by receipt number 6137 as question number 2. Signature Padmavati Meher appearing in receipt book number so and so, and receipt number so and so. He further deposed that he marked the specimen signature said to be of Surendra Jhankar as S1 to S6, specimen signature of Loknath Meher S7 to S12, specimen signature Padmavati Meher as S13 to S18, specimen signature Raghunath Meher as S19 to S24. He also deposed that he marked the admitted signature of Surendra Jhankar appearing in loan disbursement sheet as A by 1.
So
Loan
the procedure that the court has in detail examined the procedure adopted by the examiner of the question signature, no questionable document.
questionable.
Just kindly then take page 13.
My lord, should I play the second para?
Second paragraph kindly
Yes, sir.
take. From the evidence of
evidence of
PW16,
PW16, it is clear that he did not took signature of PW 8, 10, 13, 15 under the authority of the court or with the assistance of any competent magistrate. His evidence reveals that he took specimen signatures of PW 8, 10, 13, and 15 in presence of and being identified by Hari
Bodamali.
Badamali.
ये कौन है ये? You see what has happened in the case.
Mhm.
Then
in
kindly
this
read.
case, Hari Badamali has been
Anyway,
examined as PW
whether Hari Bodamali's signature in presence of Hari Bodamali would be admissible, that is another question. I don't know why the Lorded Court has entertained even that. But read still further. That is your evidence.
In this case, Hari Badamali
his evidence reveals that. He took space in presence of Hari Bodamali in this case, kindly. Yes. In this case, Hari Bodamali has been
a single word to the fact that he identified the loanees and his presence. IO took the signatures, which creates a cloud of doubt regarding identification of PW 8, 10, 13, and 15 and PW 16, apart from being IO of this case. He is also informant, and basing on his preliminary confidential inquiry and written report, this case has been initiated, and it is not expected from a senior police officer in the rank of DSP to take specimen signature of star witnesses in a casual manner. He should have prayed the court for taking specimen signatures of the loanees, or he could have took the assistance of the magistrate for taking specimen signature of the loanees. But without doing the same, he collected his specimen signatures of the loanees in a careless manner. It reveals from the evidence of PW 16, the IO that he sent the specimen signatures of PW 8, 10, 13, and 15, along with the question documents, that is, loan distribution form to the examiners, question documents. He didn't whisper a single word in his entire examination chip that he sent the receipt book for examination, and it is surprising how and under what circumstances the government examiner received the receipt book. Another distinguishing feature.
Just stop there, Mr. 16 doesn't support your case. IOD has not supported your case or did not act to support your case.
You should have resorted to the due procedure.
No, the sanctity of seizure has not been maintained.
And taking signatures also.
Signature, okay, he produced Hari Bodamali, and how the court entered Hari Bodamali. Apart from his name is Hari, I think there is no significance as far as Hari Bodamali is concerned. Why he should be entertained by a court?
And
in I mean, being the IO, being a DSP, he did not state in examination in chief that he has sent the questionable document along with the sample with signature to the government export at Kotak. Then how he received it?
Right. The court also expressed displeasure.
No, it's not a question of, I mean, it's very surprising. But definitely, Mr. Das, I don't say that something is intended to do something. That's not the my perspective is not that he wanted to favor something. It may be just a error. It may be just a error. But can that be utilized against a person?
It can be, even it's an error unintentional, it should not be viewed adversely.
Viewed adversely as far as his conduct is concerned. But can it be utilized against this particular accused? That is the sole question.
Can it be utilized against him?
It cannot be.
Same thing.
And the trial court rightly said that this entire investigation he has taken care of. ଆପଣ କନଷ୍ଟେବଲ କୁ ପଠେଇଲେ ଗୋଟେ ପ୍ୟାକେଟ ଦେଇକି ସେ ଗଲା ଆପଣଠୁ ନେଇକି ତାଙ୍କଠୁ ସେ ଗଲା ସେଠି ନେଇକି ରିସିପ୍ଟ ଦେଲା ଆଣିଲାନି ତାର ରିସିପ୍ଟ ଟା ସୋ ହ୍ୟାଣ୍ଡିଂ ଓଭର ଅଫ ସିଲ୍ ଆଣ୍ଡ ସିଗ୍ନେଚର ହ୍ୟାଣ୍ଡିଂ ଓଭର ହେଇନି constable it is it is quite but he has himself recorded, he has himself sent, and then suppose he doesn't say in the examination in chief that I have sent it. Even one do not know what the expert examiner says. He says AIG directed him to examine. Where from he got it?
And how it was routed through?
How he got it? Because that's the I mean, the whole sanctity of investigation depends on that. Then 477 it says prosecution failed to prove that he accused destroyed, altered, mutilated, falsified any book. But the reason being, I think everything has been produced before the court. So what he destroyed?
No,
not only produced, not only produced.
Fact of destruction or alteration.
Yes.
Or mutilated.
Yes. Because if it is destroyed, then what was produced before the court to examine that it is the signature of PW 51011.
Those ingredients are missing.
Is what you say. You will examine further.
No,
you are closing it. Okay. Mr. No, I mean, I am not in a hurry because I understand.
I mean,
yes.
There will be any one at least with some amount of experience in this side, my lords. Sometimes our eyes goes to the main points, for which we can apprise to the court, my lords. That puts some extra spring on your feet to say that this is a mistake where the court this particular mistake warrants the attention of the courts.
And you have not found out any.
The manner in which they proceeded or the mechanism they have resorted to is absolutely, the court also expressed.
The court has admitted Hari Bodamali.
Right. There is no allegation of destruction, mutilation, alteration.
They say page 16 ne gote achi. There is an allegation. That say that they have, but that has been rejected in view of the evidence. ସେଟା ହେଇପାରେ ଗୋଟେ ରେସିଡୁଆରୀ ହେଇଥିବ ଯଦି କିଛି ପରେ ବାହାରିବ ସେଥିପାଇଁ ସେ ରେସିଡୁଆରୀ ଚାର୍ଜ ଲଗେଇଥିବେ ଆପଣ 16 ରେ ଦେଖନ୍ତୁ ଏ ଯୋଉ
the main thing is that he said that he
let the prosecution will fail to prove the accused had forged the receipt MO6 receipt book. It cannot be said that accused had fraudulently dishonestly used MO material object 6 as genuine document. Anyway, so destruction of the poor page.
476 falsification as you. But because entire thing is that I was talking that particular way that I receive everything for AIG.
No, since what I usually find, whatever I have seen, usually the court even also doesn't wait for the witness to tell. If a simple sentence is said, as far the prosecution witness is concerned, so they complete the sentence. But somehow he has not stated anything, and he has been truthful to that extent. He has not manipulated. You will also appreciate. Mistake is a mistake. It is presented, and let it be taken care of by the court. That is the other part of it. I mean, the DSP has been diligent enough not to kind of a rear guard action. Suppose he realizes that it was never stated in the examination in chief, or record is not maintained, and the expert examiner says that I have examined that for direction of the AIG. So at least you should be, that shows the neutrality and the impartiality of the investigating officer, that he has not tried to cover it up. He could have taken some plea, which we cannot say right now, but he has simply, whatever as it is, he has presented the matter. Sangram Das for the petitioner, opposite party blank. The learned counsel for the learned standing counsel. The petition has been filed under section so and so of CRPC, seeking leave to appeal against the order of acquittal passed by the learned special judge vigilance Balangir, dated 7/4/2011, in CTR number 48 of 1005 of 2006-2007 देखिए सब बड़े लेखन तो arising out of Sambalpur vigilance PS case number so and so. In the said trial, the opposite party, sole opposite party stood trial for committing offences under section 409, so 468, 471, 470. এটা भी देखिए लिखिए भूलभाल होनी. And so section of the Prevention of Corruption Act. The learned standing counsel strenuously argued, referring to the grounds stated in the petition, to submit that due to the perversity in the judgment, the court should grant leave to appeal. However, it is also fairly submitted by the learned standing counsel that at this stage, the scope of granting leave to appeal will be confined to the material already on record. That is the statement, public depositions of the PWs and the other material objects that has been marked as exhibits before the learned trial court. This court has occasion to go through the judgment of the learned trial court dated 7/4/2011. In considered opinion of this court, the learned trial court has gone to a great extent in analyzing all the evidence and materials on record, and the findings are thus. ମୁଁ ଆପଣଙ୍କୁ ଯୋଉଟା କହିବି ସେଟା କୋଟ୍ କରିଦେବେ ହେଲା ପାର ତାପରେ ଦେଖିବେ ସାଇଟେସନ କ'ଣ ଦେବା in view of the above this court is not inclined to grant leave to appeal in the present case. The petition stands disposed of. It can be pronounced as a judgment. So thus, it can also be pronounced as a judgment disposed of, date of hearing and judgment.
Admission stage,
Yes.
Item 2.
Yes.
Item 2 में one pass over. One pass.
Let it be there on other, since we have had only one. Yes. The learned counsel, the standing counsel seeks for, after advancing arguments, the learned standing counsel seeks further accommodation to further his arguments. As prayed for after vacation or before vacation, Mr. Das?
Next week, sorry.
Okay. As prayed for, आज केते हला? एजी आपण 24 रो नाही दिडी जाक डिसेंबर कर देले 23
डिसेंबर लास्ट
भूल भाल हबनी
No, काली आसु न
December
sorry.
No, and I am just trying to look at the date. List on 7th or 8th 21 7th or
Lordship take after launch बोलो sorry
7th or 8th देख तक ला 7/12/2023.
Item 3.
Kindly be taken up on Monday, Lordship. I am not well today. Kindly.
Ms. Sasmita Nanda for the petitioner, Mr. Sasmita Nanda, three, Mr. Mahapatra, Mr. Naik, Mr. Standing Counsel. Mr. Standing Counsel for the state, learned counsel for the petitioner seeks accommodation due to as he's in this has some personal difficulty. এটা जोड़ा আমি থরে হিয়ারিং করিଥିଲେ
আগে সারদবা এই পাখরে ডেট দেই
আচ্ছা
আজি কে দেও বল
21 বিফোর ভ্যাকেশন আর আফটার ভ্যাকেশন
আর আজি ওর লর্ডশিপ আজি তেবল টাইম আছে মতে দিও
আজি তো আছে টাইম
আজি মো দেহ জমা ভাল
কেবে আপন চাহুচନ୍ତି নাই
আজি মোর দেহ জমা ভাল নাই টিকে
নাই আপন কহিলে সেন্সেস বতে ডেট সো ক্যান আই ক্যান সেভ টাইম ইন গিভিং এ ডেট
জানুয়ারি দেই দিও
ডেট কর দিও 9/1/2024
আগে
টু গ্রান্ট ফার্দার অপরচুনিটি ইয়েস
Item 4.
May I plead, Lordship?
Yes.
Last occasion, Lordship, this is a revision against the order of acquittal, Lordship.
Yes.
Here in this case, Lordship, this alleged commission of the offence.
That day I spent some time with you
My
in deliberating. Today you have heard Mr. Das. I was deliberating with him.
lord,
That is a standard approach. That is not to be changed.
my lord, PW 3.
So it is a simple, straightforward approach.
My lord,
In case of evidence of house burning,
my lord,
so you are saying that there are two eyewitnesses.
my lord,
The two eyewitnesses say they are sleeping in their house. After hearing halla, they come out
Mm.
and they see that someone running.
my lord,
Then the first case fails.
Mm.
It's the final form. Then you file a complaint after 6 months. There you improvise certain cases,
my lord,
certain instances. And the person who has seen the one of the accused with a burning stick,
my lord,
that was not the evidence in the first FIR.
my lord. But I submit, Lordship, last opinion, Lordship directed me to go through the 313 and if any other, because I have not the
313
entire.
kahingi pacharli, because 313 has a significance. Again, the recent judgment Supreme Court has highlighted.
My lord,
You see, suppose due to my lack of experience or otherwise, you are arguing a matter. Please appreciate this. Consequence ta kon hochi 313 re. Apon mate evidence present kar dele.
my lord,
What I have did in what Mr. Das was arguing, did I go to the 313 statement?
no,
I am not going because I am not checking whether it was confronted with the accused.
my lord,
So I pronounce a judgment of conviction.
Mm.
Then in Supreme Court, simply they say that see the 313 statement, he was standing with the burning stick, running away from the house, has not been asked, posed to him.
Mm.
Then that is inadmissible.
my lord. Yeah, I go through that DW1, Lordship. Lordship has asked me whether that this question has been put forth in the cross-examination or not regarding that fire stick. But the DW1's version is also same that by hearing that near lagigala, I came.
ଆପଣ ଯାହାକୁ କହୁଛନ୍ତି ଯିଏ କି accused,
My lord,
accused number 1, 2 ଦିଟା ଅଛନ୍ତି ତ?
My lord.
Let us one was standing with the stick.
my lord,
Trial court conviction କରିଦେଲେ.
Mm.
ଆଉ ସେଠି ତ ହାଇକୋର୍ଟ ଏତେ ସମୟ ନାହିଁ ବା ଯାହା ବି ହଉ lack of efficiency ଯାହା ବି ହଉ ସେ ଦେଖିଲେ ତ ଅଛି ସେ ତ କହିଛି ଯେ ତାକୁ ଆପଣଙ୍କର 3ଟା ଏଭିଡେନ୍ସ ପ୍ରଡ୍ୟୁସ କରିଛନ୍ତି ପ୍ରୋସିକ୍ୟୁସନ ୱାଇଟନେସ୍ PW 1, 2, 3 ସମସ୍ତେ କହୁଛନ୍ତି ଆକ୍ୟୁଜ ଛିଡା ହେଇଥିଲା କାଠି ଧରିକି ଜଳୁଥିଲା ତା ହାତରେ କନଭିକ୍ସନ କନଫର୍ମ ହେଇଗଲା ସୁପ୍ରିମ କୋର୍ଟ ଗଲା ସୁପ୍ରିମ କୋର୍ଟରେ ଲୋଅର କୋର୍ଟ ରେକର୍ଡ ଦେଖିଲା ବେଳକୁ 313 ଷ୍ଟେଟମେଣ୍ଟ ନାହିଁ
Mm.
ଆପଣ ଯଦି କନଫ୍ରଣ୍ଟ କଲେନି the entire trial has become goes.
my lord.
That is not admissible actually.
ಈ ಕೇಸ್ more
Specific question थिबो सेथिरे क्वेश्चन आंसर फॉर्मेट रे हिथिबो या यूजुअली कोन थाए देखाइ थो जे आपण सेठी काठी धरी अमक तारिख एते बेले छिडा हिथिले से कहबो मिछ कथा कि नाही सो सेटा आपण फर्स्ट सेटु आरंभ करियो कान आई वाज ट्राइंग टू असिस्ट यू टू बट दैट व्हेन यू गेट ए माने जजमेंट हाउ डू यू गो अबाउट इट आपण जदी सब जिन जजमेंट लाइन बाय लाइन पढिबे then it is impossible to argue a matter at a stage of appeal आपन तो बीजी चैम्बर सो बेसिकली यू हैव टू सी स्टेट अवे किए आपन PW 3, 4 कहले तांकर एविडेंस अछि कि नाही
my lord,
से जदी कोर्ट तांको ट्रीट कले जे नाही दे आर नॉट आई विटनेसेस तांकर स्टेटमेंट देखि देबे
my lord. 305.
you see I have seen courts making mistakes I am not that optimistic that courts are that even they have convicted without going to the postmortem report as a counsel I have seen and I am a judge I am also seeing for the last 2 years
ମୋ ପାଖରେ ଯୋଉଥିରେ material ଥିଲା that I have last
so 313 ne sei to accused ko pachara thila ki because Mr. Kanungo also highlighted that day that it is after almost 6 months you have
my lord.
and that has not been explained
My lord. The delay part has not been explained after final
explained
form.
obviously and when there are multiple FIRs the standard principle the law that has evolved is that fast FIR
My lord.
ଆପଣଙ୍କର FIR ତ complaint gross variance ରହିଲା
My lord. Final form ରେ ହେଇଗଲା ପରେ 6 ମାସ
I think that complaint case should not have been entertained. First of all, complaint case should not. तापरे कौन हैला? पुलिस तांका ड्यूटी बोधे कलेनी. They felt pressurized. They felt pressurized and file a charge sheet.
Yeah, the entire prosecution is on basing upon PW 3 and 5. Only case that evidence I have deliberately because I have no other documents. Lordship. Whether that question has been put for no my learned senior as there. But whether that fire stick part has been examined or not, or cross examination has been question has been put for or not.
DW ର ତ help କରିବନି ଆପଣ PW କିଏ କହିଛନ୍ତି
PW 3 and 5 that
ହଁ ଏବଂ ଯିଏ accused କୁ ଆପଣ ଡକ୍ ରେ ପଚାରିଛନ୍ତି
Fine.
13 ରେ ପଚାରିଥିଲେ ସେଟା ଥିବ ଯେ ସେ ଛିଡା ହେଇଥିଲା ଏଠି କାଠି ଧରି ଛିଡା ହେଇଥିଲା ଜଳଉଥିଲା so we are closing it
Fine.
Pragya Mahanti on behalf of the petitioner opposite party blank এটা item 4 the petition has been filed seeking leave under section 401 read with section 397 of the Code of Criminal Procedure seeking leave sorry at a leave grant seeking revision of the order of the judgment dated 23/4/2011 passed by the learned Assistant Session Judge Jaleshwar at in the district of Balasore in sessions trial number 12 of 2010 acquitting the accused persons who are the opposite parties in the present case for the offences under section 436/34 of IPC. The learned counsel for the petitioner, referring to the judgment, especially the evidence of PW 4 and PW 3 and 5, submits that the conclusion of the learned trial court regarding the innocence of the opposite parties, oblique, the prosecution having failed to prove the allegations against the accused persons beyond all reasonable doubts, should be set aside, and the judgment of acquittal should be reversed to that of a judgment of conviction. Para. This court has the occasion to go through the judgment as has been appended to the petition, as in annexed to the petition. The learned counsel for the petitioner placed before the court the depositions of PWs 3, 4, and 5, who are supposed to be the star witnesses of the alleged occurrence. Dealing with the depositions of the said witnesses, said PWs, the learned trial court has given its analysis in the following paragraphs of the judgment. The court para. The learned counsel for the petitioner, however, also fairly submits that while exercising the jurisdiction for revising the order, this court has to confine itself to the materials already on record, that is the depositions of the witnesses and other evidences produced by the prosecution, and beyond the said available materials, she cannot submit to challenge the judgment. Having heard the learned counsel for the petitioner and considering the material on record and analyzing the judgment passed by the learned trial court, in considered opinion of this court, the trial court judgment cannot be interfered with, and the petition stands disposed of. It will be further detailed order, but to save time, I am just giving an outline. Yes, please. You are saying something?
No, it's fine. I'm good.
Yes.
Item 5,
Mr. Asit Kumar Jenna for the petitioner. Mr. Standing Counsel for the State, the learned counsel for the petitioner seeks accommodation, stating that the case brief has been misplaced and he may be granted time to reconstruct, public retrieve the same. As prayed for list on 16/1/2024.
My lord, may I kindly see
The surrender certificate. The flag कितने रहे? In terms of the earlier order dated 8/11/2023, the registry shall request the learned court in session of the matter to provide instruction regarding surrender of the petitioner after the period of interim bail, after the period of thila.
That is, my lords, convicted for a period of 2 years, my lords. And the process is that, my lords, he has to surrender, my lord, and subsequently bail.
Yes.
So that instruction, Honorable Court.
And according to you, he has never surrendered after it was
That I have to take instruction, because, my lord.
Then
that earlier orders, your lordship may kindly see.
अच्छा सेटा आपण 22/13 रे हाई कोर्ट ऑर्डर करछथि.
Yes, your lordship.
आपण तो थिले से आपण ही काउंसिल थिले.
नहीं.
आपण मन
File has been misplaced.
No, I understand. No, that I understand. आपण से आपण अजित हे जाइथिले तापर
नहीं.
अस्थित करी के आपण को से
नहीं.
कहले जे सर्टिफिकेट दियन. कोन लिखले सेंटेंस ता 8/11/23 reiterating the order dated 22/8/13.
22/7/13
हमर 8 हे जाई.
तापर 13/8 तापर 22/8 22/7
Reiterating the earlier order stated 22/7/13, 22/8/13.
Yes.
Order number 5 होची 22/7, 7 होची 22/8. Yes, next.
Item 6.
What I call it? To be called again at 2 p.m. Yes, next.
7.
To be called again.
My lord,
7, yes.
my lord, I'm appearing on behalf of Mr. Vinay Kumar Mahanti, who's the counsel for the petitioner.
Ms. Ipsa Kanungo on behalf of Vinay Kumar Mahanti for the petitioner.
My lord, I've received telephonic instruction that Mr. Mahanti met with an accident last Friday, and currently he's hospitalized and receiving treatment for brain stroke and spinal injury. So may this matter be taken up to some other date.
And he has suffered serious injuries. Opposite party blank. The learned counsel for the adjournment is sought for on behalf of the learned counsel for the petitioner as due to personal difficulty. On 13/11/2023, the following order was passed. Considering the prayer of the prayer for adjournment, the matter is adjourned to January date kar diyo to
On 3.
29/1/2024, 29 January. Yes.
Yeah. Much obliged.
Yes, please.
Item 8.
Yes.
My lord, on behalf of Mr. N. Linka, this matter kindly not raised.
So filing a memo. You are Miss Rasmita Sahu. I'm sorry.
A. Rana, Subbalakshmi Rana.
I'm so sorry. M.S.S. Subhalakshmi Rana on behalf of Niranjan Lenka for the petitioner. Mr. Standing Counsel for the state. What is the nature of
Order of cognizance is in challenge.
the Learned Counsel for the petitioner files memo stating that the petitioner doesn't want to pursue the matter any further. Memo dated, the said memo stops, the said memo dated 1/12/2023 is taken on record. The petition stands disposed of.
Much obliged.
Yes, please.
Item 9,
To be called again.
ten,
10-14 ମସିହାରେ କଣ ନେବେ ଏବେ କରିବେ? How?
The reason being, this is a case pertaining to a trap. And PW3 is the decoy. In a trap case, there are two eyewitnesses. Decoy, the complainant, he will be accompanied by another person known as a shadow witness or accompanied witness.
Magisterial witness.
No, not magistrate. The accompanying witness or the shadow witness.
I think he's called magisterial.
Magistrate witness are there in the trap dreams. There's a meeting there. After getting that,
But not the magistrate.
no, not in the magistrate.
Magistrate. Yes.
So they are known as, but in the field, my lords, the trap is to witnessed by two persons. One is the complainant known as decoy. Another person who accompanies the accompanying witness. Another synonym is the shadow witness. So both the shadow witness duty is customary to see the act of transaction, the factum of demands, and thereafter he gives signals to the other reading party member who are waiting at a distant place. So on the call of that shadow witness, the other reading party rushed to the particular room where
They have not supported the prosecution case.
No. Here, the early demand was 500 rupees for issuance of a pota. The accused in this case, opposite party is RI. So issuance of pota, he demanded 5 rupees. Earlier demand was fulfilled, 200 was paid. The another 300 was to be paid by the decoy or the complainants. He reported to the vigilance.
No, that's the
laid the
prosecution
traps.
story. No, then why he was acquitted?
He was acquitted because the statements PW3, the decoy, and PW1, the over witness, were not found trustworthy by the learned trial courts.
Apparent discrepancy. Mr. Sangram Das, Standing Counsel for the state, learned opposite party blank, the learned Standing Counsel. After advancing arguments for some time, seeks accommodation to further the arguments as spread for list on
16.
January or February.
January.
16/1/2024. Yes.
11,
2020 matter.
11 months, February months.
11 February कर दियो.
12,
Same order. 12/2/2024. Yes.
12,
To be called again. Yes, next.
13,
To be called again. 13 is there. Are you there, madam? Your name, madam?
Sir thille M.S.Sahoo.
14 bracket.
14,
14 my lord, CD is required.
Mr. Nityananda Mahapatra for the petitioner, Mr. Standing Counsel for the state. It is listed for the fast track.
Yes,
My lord.
earlier was rejected. It was rejected by your lordship.
ଏଟା 21/11 ତ ଆସିବନି, ଏଟା କଣ କି ରିକ୍ୟୁଜାଲ ହେଲା କି?
Earlier, my lord, earlier bill application 9/3, my lord, that 9/3,
Acha.
3/2/23 and disposed of by
Acha.
my lord.
Before charge sheet.
ଆପଣ ଚାର୍ଜ ସିଟ୍ ପରେ ଫାଇଲ ମୁଭ କଲେ,
Yes, yes.
Charge sheet ପରେ
ସେଟା ରିଜେକ୍ଟ ହେଇଯାଇଛି.
ଏବେ
Okay.
charge sheet ହେଇଛି ଫାଇଲ କରିଛି
PWs କିଛି ଆସିଲେଣି? କେତେ ବେଳେ ଗଲା ଟ୍ରାଏଲ?
କିଛି ଟ୍ରାଏଲ ଆରମ୍ଭ ହେଇନି
ତାହେଲେ ଟିକେ ଅପେକ୍ଷା କରନ୍ତୁ.
ଆଜ୍ଞା କେସ୍ ଡେଟ୍
ଆପଣ ଯଦି ଗୋଟେ ଦୌଡ଼ି ଦୌଡ଼ି ଯାଇ ବାଡେଇ ହେବେ ଗୋଟେ ଜାଗାରେ, ବାଡେଇ ହେଲେ କଣ ହବ? There will be some injury. ମୁଣ୍ଡ ଫାଟି ପରେ କଣ ଇଞ୍ଜୁରି ହେଇପାରେ?
ଆଜ୍ଞା
You may ମତେ ଲାଗୁଛି ବେଳେ ବେଳେ ସେୟା ହିଁ ହଉଛି. ଆପଣ ଜଷ୍ଟ ଲିଷ୍ଟ ହଉଛି, ଆପଣ ମୁଁ ଆପଣ ମ୍ୟାଟର ଆପଣ ତ ଫାଷ୍ଟ ଟାଇମ ଆସିଛି,
ଆଜ୍ଞା
ଏଟା ଖାଲି ଲିଷ୍ଟ ହେଇକି ଗଡୁଛି, ଅଲ୍ଟିମେଟଲି କିଛି ହବାର ନାହିଁ.
ଆଜ୍ଞା
ଆଟଲିଷ୍ଟ ଚେନ୍ ସର୍କମଷ୍ଟାନ୍ସେସରେ ଆଉ ଥରେ ଫାଇଲ କଲେ କିଛି ଗୋଟେ ହଅନ୍ତା.
ଚାର୍ଜ ସିଟ୍ ପରେ ତ ମୁଁ
ଚାର୍ଜ ସିଟ୍ ପରେ ଚାର୍ଜ ସିଟ୍ ରେ ଯୋଉ ମ୍ୟାଟେରିଆଲ ଆପଣଙ୍କ ୱିଟନେସ୍ କଣ ଏକ୍ସାମିନ ହେଇଛନ୍ତି, କିଏ ଆପଣଙ୍କର କୋଉ କୋର୍ଟରେ ଭାରତରେ ମିଳୁଛି ବେଲ୍ କହିଲେ, ଏଇ ଯୋଉ 376(3) ରେ
ମେଜର ଗାଲ ଲାଗେ
मेजर गाल रे 376 रे बेल मिलिबो एटा
ନାଇଁ, ତାଙ୍କ ଭିତରେ ସେମାନେ 2 ବର୍ଷ ସାଙ୍ଗରେ ରହିଛନ୍ତି ଆଜ୍ଞା। ସେଇ କଥା
ସେଇଟା
ହଉଛି
ଆଜ୍ଞା,
status ଟିକେ କମିଗଲା। ଇଏ ହଉଛି ମାନେ ସିନିୟର ନର୍ସ ଆଜ୍ଞା, ବହୁତ ପଇସା ପାଉଛି। ଇଏ ଏକା ଗାଁ ପିଲା ଆଜ୍ଞା, ଆଉ ଇଏ ହଉଛି ସିକ୍ୟୁରିଟି ଗାର୍ଡ। ତେଣୁ ପ୍ରିଭିୟସଲି ତାଙ୍କର ଲଭ୍ ଥିଲା। ଆଉ
ତାଲେ
ଯେତେବେଳେ
ତାଙ୍କୁ
status
ସେ
ବଢିଗଲା,
ତାଲେ
ତେଣୁ ସିଏ ରାଜି ନୁହଁ।
ଆପଣ ଯୋଉଟା থিওরি কোচন সেটা জাস্ট
ନା
অপোজিট
theory ନୁହଁ ଆଜ୍ଞା, ସେଥିରେ
yesterday you asked Mr. Yesterday you can check with Mr. Standing Counsel
କେସ୍ ଡାଇଟ୍
the girl after getting married
ଆଜ୍ଞା
because you are saying that she is of higher status and she has a better social life.
ଆଜ୍ଞା।
She will avoid all these things.
ପିଟିସନର ଚାହୁଁଛି ବାହା ହବା ପାଇଁ, ସିଏ କିନ୍ତୁ ଚାହୁଁନି।
Christian ତ ଚାହିଁବେ ସେଟା କଥା ପଡିନି ଆପଣ କଥାର କଣ୍ଟେକ୍ସଟ ଟା ବୁଝିଲେନି
ଆଜ୍ଞା
she is comfortable in her social status
ଆଜ୍ଞା।
she will simply say that I am not interested in this matter no one will lodge a complaint yesterday something like that has
ସେ
happened actually
ତାର ବାହାଘର ଅଲଗା ଆଡେ ଲାଗୁଥିଲା ବେଳେ ଇଏ ଏଟାକୁ ଅବଜେକ୍ସନ କଲା। ସେଇଟା ହଉଛି ଆଜ୍ଞା ପ୍ରୋବ୍ଲେମ।
obviously
And threatened to viral the photographs.
ନାଇଁ ନାଇଁ, no no my lord,
That is there in the
Annex
rejection
of
order.
3 ଆଜ୍ଞା 15/7/21 ରେ ଆଜ୍ଞା ସେମାନଙ୍କର
Mahapatra,
ପିଲାଟିଏ ଜନ୍ମ ହେଇଛି।
Mr. Mahapatra, before you say no, be sure that the lawyer has not read. बुझले कि he is also a lawyer, and please also think that the judge, be sure that judge doesn't understand anything. ये जो no style I don't understand. तो आपण कहला पर she should सेटा point out करिवे एही जगह रे एई स्टेटमेंट देइतला तो तापर आपण कहबे जे नाही सेटा आ गोटे कोन कहबे
In the meantime, marriage.
तापर
was
कोइ से
fixed.
फोटोटा victim उठैतला आ कोन explanation
The
हबो
petitioner made viral her photo and broken her marriage.
my lord, Annex of 3 ରେ ସେମାନେ 15/7 ରେ ତାଙ୍କର ଗୋଟେ ପିଲାଟିଏ ଜନ୍ମ ହେଇଥିଲା କ୍ୟାପିଟାଲ ହସ୍ପିଟାଲ ରେ। ସେଇଟା ପରେ ସେଟା କିନ୍ତୁ 200
so please be sure आपण आगो बुझी देबे जे आपण पढिचंती कि नाही
ଆଜ୍ଞା आଜ୍ଞା। କେସ୍ ଡେଟ୍ ଆସୁ my lord।
प्रॉब्लम कोन होय कि जेतेबेले पिटिशनर काउंसिल कहंती स्टार्ट कम्युनिटी टिके देखिबे सेटा बेसी पढि दियंती you ask Mr. Senapati was sitting Senapati I don't today he is not there our senior Mr. Senapati was the information after again he has come back to bar
Yes.
तो आपण सेमती श्योर हेबे ना जे से पढि ना आपण कॉन्फिडेंटली नो भाइरल कहला पर आपण कहने सेटा सीए भाइरल करथिले आंको ब्लैकमेल करिया पे
ଭାଇରାଲ ଫେର ସିଜର ହବା ଦରକାର ସବୁ କଥା ଖାଲି ପଢିଦେଲେ ହବ।
yes Mr. N.K. Mahapatra for the petitioner, Mr. Standing Counsel for the state. The Standing Counsel shall obtain, the learned counsel for the state shall obtain up-to-date case diary along with instruction, public status of trial, para. Specific instructions shall be obtained from the investigating agency regarding the possibility of the objectionable material being circulated in any kind of digital platform in view of the allegations made in the matter against the petitioner. Kebe adiba Mr.
My lord, it is there in our office that has been
Up to date anantu.
Yes, Lord.
Because in all these kind of matters, you are getting that after I direct, you are getting that instruction.
Yes.
In some cases, you say that there is no possibility.
My lord. 2 weeks after.
आपण कोन स्टेटस में रिकॉर्डिंग करथिले कि
ନାଇଁ ନାଇଁ
आपण को स्टेटस कम बोले रिकॉर्डिंग कर रखथिले
ନାଇଁ नाଇଁ
आ के रिकॉर्डिंग गला पिटिशनर एटा विक्टिम रिकॉर्डिंग करथला
ସେ ପିଟିସନର ନିଜେ ବାହାବାକୁ ଇଚ୍ଛା ଯେହେତୁ ୟାର ଅଲଗା ଜାଗାରେ
रिकॉर्डिंग सर बाहागर रिकॉर्डिंग नो
ନାଇଁ
ऑब्जेक्शनल मटेरियल जोटा आपण बर्तन सर्कुलेट हैला
as for instruction and
के रिकॉर्डिंग करथला सेटा हु हैज रिकॉर्डेड दैट सेटा पचार नांती आ कोन ताले जेतरे पिटिशनर आछुंदी केस बेल दवा पई एटा फास्ट पचारिबे
आगे
तो बाबू कोर्ट एटा पचारिबे तुमको एंड इन जोथरे पॉसिबिलिटी थिबो से एबे बाहरी बार नाही
ନାଇଁ आईटी एक्ट भी
जदी पॉसिबिलिटी कौन से लगे छथि म कहि परिबे
आगे आगे
कौन से लगे छथि
आईटी एक्ट नाही
यू सी इन वन मैटर मिस्टर महापात्र आपण बुझी पाउ नांदी
आगे
से धमकेले किंतु एक्चुअली किछि नथिला आपण सबले कोन प्री ऑक्युपाइड माइंड रे आछंती आपण जदी क्वेश्चन द पर्पस टा बुझीबे दैट वाज दैट दे ऑब्टेन द इंस्ट्रक्शन
आगे
देयर वाज नथिंग
माइल
आपण तो सेटा बुझी नांती कोन पचार नांती तांको once there is an allegation that he has circulated the material maybe जे तांकर जहा संगे बाहागर प्रस्ताव पड़ता तांको पठै देले I got an incident re. I can also tell you. The material was sent to the cousin sister or sister-in-law.
My lord.
So as such, there is no possibility of circulating it, and that has been deleted. Now they take that, they provide that instruction. 18 ତାରିଖରେ ଆସିବ?
ମାନେ 18 ତାରିଖ ତା ପରେ 20 ରେ ଆସ
20
ଆଜ୍ଞା।
20 ରେ ଆଣନ୍ତୁ. You get that, you again up to date case diary and get that instruction. Yes.
Oblige.
One item Passover.
Yes, one Passover. Yes.
13.
13.
13.
My lord, I have challenged the judgment dated 27, my lord, the passed by the 1st June 2023. In acquitting the
Yes.
respondent, my lord.
Yes.
Case under 138 of the NI Act.
Yes.
The case of the petitioner that
ଆପଣ state of evidence को आसନ୍ତୁ. Mr. Tripathi, let us save some time
my lord,
because we are having a variety of assignments and reads are coming at the bottom.
yes, my lord.
Hearing matters.
My lord,
They
this
are
is-
saying that it should go up
no,
and bail matters
so,
have to be taken up.
so I
ଆପଣ
pray that
କୋଉ evidence ରେ ଆପଣ impressed?
my lord, the only the Lord Court below has disbelieved the story that since as per the 138 NI Act, my lord, the notice must be served to the drawer of the check, my lord.
Yes.
My lord, I have sent the check in his home address. In the address shown by him in the bank passbook. But the postal endorsement is that address is left. So in the meantime, my lord, that 15 days, 1 month period of the filing of complaint petition is going to expire. So after I know that he is now residing at Bhubaneswar. He left the village and no Bhubaneswar.
Address left, nothing thila kintu.
Address left.
And that is your case also.
Yes, ma'am.
That is a matter of record also.
So
Okay.
I inquire from the villagers, he is residing at Bhubaneswar. So in the complaint petition, I added the his current current address, my lord, of Bhubaneswar, and notice was sent to him. And Lord Court below has disbelieved that since the notice was not served on him, on this ground, the
ଆପଣ अरे disbelieved जे ଆପଣ ସେନା ଆଗ କହିବେ ଯେ what was produced to court for the court to consider that it was served ସେଟା ଆଗ କୁହନ୍ତୁ.
ନାଇଁ ସେ endorsement ସେମାନେ ନେଇଛନ୍ତି ସେ ଯୋଉଟା address he left
ଫାର୍ଷ୍ଟ ଗଲା ସେକେଣ୍ଡ ରେ ଆପଣ ଭୁବନେଶ୍ୱର ଆଡ୍ରେସ ଦେଲେ.
ହଁ ସେ appear କଲେ contest the matter
ଭୁବନେଶ୍ୱରରେ କଣ ହେଲା ନୋଟିସ ଟା
ଭୁବନେଶ୍ୱର ସର୍ଭ ହେଲା ସେ appear କଲେ.
ତାହେଲେ what is the occasion to say that he was not noticed?
Yes, my lord, that is my case.
କୋଉଟା ଦେଖେଇଲେ କୋଉ ପାର୍ଟ ସେଟା ଡିଲ୍ କଲେ ସେଟା
My lord, your lordship can page 12, my lord.
ଆପଣ ଟିକେ ଏଇଟା ପଢିଲେ ଯୋଉ ଆପଣଙ୍କର ରନିଂ ପେଜ 15
my lord.
ସେଟା ପଢନ୍ତୁ ଫାଷ୍ଟ ପଢି ପାରିବେ though not relevant ପଢି ଦିଅନ୍ତୁ.
My lord, accused are strongly reputed to have received any demand notice
Yes,
from the
please.
complainant.
Please.
Therefore, at this juncture, it is necessary for the complainant to prove that the accused had duly received the demand notice regarding the discharge of theft. The complainant has proved by exhibit 2 that the accused had issued him the
slowly. It's good that you are immediately going to the page. Up ଟିକେ slow ପଢନ୍ତୁ.
Sorry, sir.
ମାନେ speed, yes.
The complainant has proved by exhibit 2 that the
ଏତେ ସ୍ଲୋ ନୁହଁ ଆପଣ ଯୋଉଟା full stop ଆଉ comma ରେ ମାନେ ଟିକେ ଅଟକି
exhibit 2 that the accused has issued him the alleged check dated 3/5/2018. The complainant has also proved by the exhibit 3 and exhibit 4 and exhibit 6 that he has presented the check within the due time which was dishonorable due to fund insufficient, after which a pleader notice was sent to the accused for payment of such money. But during the course of trial, the accused strongly denied to have received any pleader notice, which is a condition precedent to constitute an offence under section 138 of the NI Act. On perusal of the evidence in chief,
slowly ପଢନ୍ତୁ. It is relevant.
on perusal of the evidence in chief of the complainant by para 5 as well as in the complaint petition para 5, it is stated
Para 4.
Sir. It is stated by the complainant that the pleader notice was returned by the post mentioning addressee absent.
So ହେଲା ସେଟା ତ ଆପଣ ବି କହୁଛନ୍ତି ଯେ ମାନେ ସର୍ଭ ହେଇ ନଥିଲା. You are not disputing.
No.
Then
the complainant also deposed by 35 in the evidence that I cannot say whether the accused has knowledge of bouncing of the check or not, which means
is it a fact ଆପଣ ସେଟା statement ଦେଇଛନ୍ତି?
No.
ଦେଖାନ୍ତୁ अपन डिपोजिशन आनी छंती
आगे
ये कंप्लेनेंट का केते PW2
PW1
PW1
I have
देखो
filed a complaint case. This said is the complaint case. You lordship page 26.
एटा कोन एटा 8 रु केमती आरंभ हो गला
8 8
संतोष कुमार स्वाई इज द कंप्लेनेंट
आगे
एटा पारा 8 रु कोन आरंभ हो गला पेज 26 टा देखछोंती तो
हाँ आगे यार 8 हला मो कंप्लेंट पिटिशन रो हला 7 जाके 7
कंप्लेंट पिटिशन टा 7 जाए
आगे
हां 7
आगे तापर 8
7 गोटे कोन हाथ रे लिखाई छे हैंड
हाँ तापर 7 that
yes.
case is filed delayed due to advocate strikes from 31/7/18 to 25/8/18.
कोड सेटा
मिले
सेटा कोड से ट्रायल कोड सेटा कोठु आनिले सेटा देखंतु
I am not followed मैंने
21 पढिले
page 21
नाही सेई जो आपण 8 रु आरंभ होईची
माइलो
पेज 27 आपण
Right,
जोटा 8 अछि सेटा होची आपणकर पेज 26 पण
आगे
कहउतिले
हाँ 26
देख then you then the read 21 paragraph
21 paragraph my lord I cannot say that is my lord
please
I cannot say whether the amount entered in the check and the signature on the check are the handwriting of same person or not.
yes the accused is retired sergeant from Air Force then 23
I cannot say whether before 2018 the accused was staying at Bhubaneswar or not.
yes
The accused was working as electric contractor after his retirement.
yes
He has taken work order from Khordha and Noagarh district. I was working as supervisor under the accused contractor. I was supervising the work done by the employees of the contractor. It is not a fact that I have given 1 lakh to the employee of the contractors of the contractor.
35 तो से clearly कहउचोंती
I
टाइप
cannot
करी
say whether the accused has knowledge of bounce check or not. It is a fact that someone was issued at the Bhubaneswar address.
then
of
Mr.
the-
Tripathi what is left आपण तो affidavit करके दे देले
No, it is affidavit no, it is a cross examination.
whatever से जो येटा आपण कहले ना सेटा कोन पार्ट ऑफ द कंप्लेंट पिटिशन सेत पे पारा से 8 हे गला सेत पे मु बुझिले
हाँ
जदि गोटे डिपोजिशन आरंभ होला पारा 8 रु केमति स्टार्ट हैला मु सेटा बुझ पर
cross रे आगे जेतेबेले सरीबो डिपोजिशन टा
नहीं सेटा आगे मु किछटा जानि छी जे पारा 8 केमति हैला आपण कहउछनी एटा पार्ट ऑफ द पिटिशन
7 जंगे इटा पर कंप्लेंट पिटिशन होला इट इज एविडेंस एंड एफिडेविट तापर 8 रु आरंभ होला इट इज ट्रीटेड एज
आपण जदि क्रॉस रे कहिले हा ओके एनीवे जदि आपण क्रॉस रे कहउछन जे सेटा मु जानिनी बोलिया कोन करियो कोन करियो
मु सेटा किंतु मु तो he has stated in his he has stated that
ना यू एग्जामिन फर्दर नो केस
I will
आपण निजे अरे
my I got the point.
no I mean what a lawyer can do
No, no,
or for that matter you see when he himself says he doesn't know then what can be done
my humble submission my lord. Once
नहीं सुनंतु एविडेंस को केबेले सबमिशन रे कवर करी होबनी
नहीं
देयर इज नो लीगल पॉइंट फर्स्ट ऑफ ऑल यू हैव टू ओवरकम द मटेरियल ऑन रिकॉर्ड फैक्चुअल एस्पेक्ट्स
yes
so the evidence is on record
no.
then you have to show a decision direct decision on the point
Okay.
that even the complainant says that I do not know still the court can proceed
no complainant no bounce upper knowledge टा
नहीं नहीं आपण सेटार that's not a subject matter of deliberation आपण पढिबे जा सी जेति को सेति
से ताटु
हमर
ये कर
एटा कोन इंटरप्रिटेशन ऑफ
ना, ना,
statute the court cannot interpret it also
yes
34 रे देखंतु आपण 33 जे ठीक अछि 34 रे से कहउछन जेटा आपण भी कहिले
okay
address is not available in the village address is absent then I cannot say whether the accused has knowledge of bounce check or not सरला
you know after getting the notice from the court he has appeared
अरे आपण कोर्ट नोटिस को कंप्लेनेंट नोटिस आगे कंफ्यूज करी गले
no
शुणंतु एनी सपोज ही वुड नॉट हैव अपीयर्ड टू द कोर्ट नोटिस ताले कोन हिथांता
NBW ହେଇଥାନ୍ତା।
Exactly. ତା ସାଙ୍ଗରେ କଣ କହୁଛନ୍ତି he has appeared after issuance of notice from the court.
ନାଇଁ ସିଏ
ଆପଣ କୋର୍ଟ ରେ appear କଲା ପରେ
ହଁ।
କୋର୍ଟ ରେ ସିଏ appear करे, that is one thing. ଆପଣ how that will, by that how you will overcome para 35 of your statement.
My submission, my lord, in the corner 42 Act, the drawer of the check to
ଦେଖାନ୍ତୁ provision ଦେଖାନ୍ତୁ that the complainant doesn't, if says that he doesn't have knowledge.
he has
Still it can be done.
my lord, may I submit, my lord? Once a check is bounced, my lord, notice was issued to the drawer of the check, also the
ଆରେ ଆପଣ discussion କଣ, ଆପଣ ଗୋଟେ ଭାଷଣ ଦେଇ ଚାଲିଛନ୍ତି। ଆରେ ଆଜ୍ଞା ଆପଣ straight you catch the bull by horn. You read para 35 and answer that. What the court can do. ଆପଣ ମତେ ପଢେଇଲେ ଯେ ଆଗ cross examination ହୁଏ, ଆଗ ହୁଏ chief, ତାପରେ ହୁଏ cross examination। ମୁଁ ପଢିଲି, ତାପରେ ପଢେଇଲେ ଯେ 142 ପଢେଇଲେ ଅଛି। ଆପଣ straight away provision କୁ ଆସନ୍ତୁ। Straight away come to the provision. That there is no requirement of a proof by the ଯଦି ବି କହିବ ଯେ I have said it, that is enough.
I have said it is already proved. I have sent the notice.
ଆରେ ନାଇଁ ଆଜ୍ଞା ଆପଣ କହୁଛନ୍ତି I do not know. The problem is that there is a return by the postal authority that he has
address he left.
That is your evidence.
Yes.
ଆପଣଙ୍କର next evidence ହେଲା ଆପଣ agitated ହୁଅନ୍ତୁନି। ତାହେଲେ ବୁଝି ପାରିବେନି। Don't get agitated. ଆପଣ କୋଉଠି prove କଲେ by what? ଆପଣ ତ କିଛି ନାହିଁ। ଆପଣ ଖାଲି କହୁଛନ୍ତି କୋର୍ଟ ନୋଟିସ ରେ ସେ appear କଲେ। କୋର୍ଟ ତାର ବୁଝିବ, କୋର୍ଟ NBW କରିବ। କି ବେଲେବଲ ୱାରେଣ୍ଟ କରିବ।
କୋର୍ଟ ଥ୍ରୁ ରେ ସେ appear କଲେ।
ସର ସେଟା କେସ୍ ଇନିସିଏଟ ହେଲା ପରେ, ବଟ୍ ଥରେ ଇନିସିଏଟ ହେଇଗଲେ it will end in conviction। ଆଉ ଏଭିଡେନ୍ସ ହବନି।
His case is not that he has not issued the check to me, my lord. His case is that he has not noticed.
Sir, don't go on conjectures. ଆପଣ ହେଇଥିଲେ ଆପଣ ଜଜ ହେଇଥିଲେ ହୁଏତ କନଭିକ୍ସନ କରିଦେଇଥାନ୍ତେ। ମୁଁ ହେଇଥିଲେ କରିଦେଇଥାନ୍ତି, let us assume ମୁଁ ଟ୍ରାଏଲ କୋର୍ଟ ହେଇଥିଲେ କନଭିକ୍ସନ କରିଦେଇଥାନ୍ତି। ବଟ ଇଜ ଦ୍ୟାଟ୍ ଏ ମ୍ୟାଟର ଫର କନସିଡରେସନ? ଆପଣ ପାରା 35 ଯୋଉଟା କୋର୍ଟ ରିଲାଏ କରୁଛନ୍ତି, ୟୁ ଷ୍ଟେଟ୍ ଆୱେ କୋର୍ଟ
ସେଇ ଲାଇଟ୍ ରେ ଗୋଟେ ଜଜମେଣ୍ଟ ଆପଣଙ୍କୁ ଆଣିକି ଦେବି।
ମତେ କଣ ଆଣିକି ଦେବେ? ଆପଣ ତ କହିବେ ଯେ ସେ ଆଜ୍ଞା even if the complainant doesn't know that it has been notice has been served, still the court will proceed.
Yes,
the point is very simple.
ନାଇଁ notice ଟା ସେଇଟା
yes, any other point ଆଉ କଣ ଅଛି? 35 ତ ଆପଣ ଦେଖେଇଲେ ସେଟା।
35 ସେ once the onus is on the drawer. Once admitted that he issued the check.
ନାଇଁ ଆପଣ ପଢି ନାହାନ୍ତି ତାହେଲେ। You have not read 138. ପଢନ୍ତୁ 138 ପଢିବା ଆରମ୍ଭ କରନ୍ତୁ। onus is on the drawer. Smile kale kon hoba aigya? We are in YouTube, we are live also. I am also conscious of that.
No, madam. May I read, madam?
I am requesting you to read. You are asking permission. Koti achi je onus is on the drawer.
It comes.
No. You have to read that. You are smiling and throwing tantrum. Now you read. Now you read. Yes.
Preparing.
You are so well prepared. You are smiling and throwing tantrum. Read, or I will read 138 to find out where it is that onus is on the drawer to that even
where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out that account for the discharge.
Out of that account.
From out of that account for the discharge in whole or in part of any debt or other liability is returned by the bank unpaid, either because of the amount of money standing to the credit of the account is insufficient to honor the check, or that he exceeds the amount arranged to be paid from the account by an agreement made with that bank, such person shall be deemed to have committed an offense and shall, without prejudice to any provision of this act, be punished with the imprisonment for or with fine, which may extend to twice the amount of the check or with both.
ପ୍ରୋଭାଇଡର ପଢିବେନି ନା ସେଟା ଡିଲିଟ ହେଇଗଲା ଆପଣଙ୍କର?
ନାଇଁ ପଢୁଛି।
ହଁ ଏଟା ଇମ୍ପୋର୍ଟାଣ୍ଟ, ଏଟା ତ ସବଷ୍ଟାନ୍ଟିଭ ଅଫେନ୍ସ।
Provided that nothing contained in this section shall apply unless the check has been presented to a
proviso ରହିଲା, it is provided unless. Yes, double emphasis.
The check has been presented to the bank within a period of 6 months from the date on which it is drawn or within the period of its validity, whichever is earlier. The payee or the holder in due course of the check, as the case may, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of the information by him from the bank regarding the return of the check as unpaid, and the drawer of such check fails to make the payment of the said amount of money to the payee, or as the case may be, to the holder in due course of the check within 15 days of the receipt of the said notice.
B ର interpretation ଆପଣ କଣ?
My humble sir on that issue, my lord. Suppose
B.
B, yes.
What is your humble submission on
B, my lord.
that 138 proviso B?
B. If my lords, the case of the accused is that he has not received the notice.
No. ଆପଣ କଣ ପଢିଲେ ତା?
The
35
payee
ଟା
of the
ପଢନ୍ତୁ।
holder.
ଆପଣ accused କୁ ଆମେ ଯାଇନେ ବିଲକୁଲ। ଆପଣ 35 ଟା ପଢନ୍ତୁ।
35.
Para 35 of your deposition, page
Yes.
28.
Yes.
ତାପରେ B ଟା ପଢନ୍ତୁ। Then you will understand.
35 ର ସେ କହିଲା ଯୋଉ I cannot say whether accused has knowledge of bounce of check or not.
Then kindly read B.
B.
Proviso B.
The payee or the holder
Provided
in
that, no, ସେମିତି ପଢନ୍ତୁନି। ପୁରାଟା ପଢିବେ ନା। Provided that
Provided
nothing
that
contained in this
section shall apply unless the payee
the payee
or the holder in due course of the check, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check.
further ପଢନ୍ତୁ, complete କରନ୍ତୁ।
Of the receipt of the information by him from the bank regarding the return of the check as unpaid.
So that is a mandated provision that
Yes.
unless it is so 35 ରେ ହେଲେ କେମିତି be satisfy
I
ହେଲା?
have sent the notice.
ଆରେ ଆପଣ ନୋଟିସ ପଠେଇ ନାହାନ୍ତି ବୋଲି କୋଉଠି କିଏ କହିଲା? ଆପଣ କହିବେ ନା ଯେ once he sends the notice ସେଟା ତ ନାହିଁ first of all, that is your imagination.
No.
Once the notice is sent, it is sufficient, ସେଟା କୋଉଠି ନାହିଁ।
ଅଛି।
ଆପଣଙ୍କ ନୋଟିସ ଗଲା।
Again, ଯଦି once a notice is sent,
କୋଉଠି ଦେଖାନ୍ତୁ 138
I'll show the distance. ସେ distance ଟା ନାହିଁ ବୋଲି ମୁଁ ଆପଣଙ୍କୁ time
ନାଇଁ ସେଇଟା ନୁହଁ ଆଜ୍ଞା 35 B କଥା para 35 କଥା ପଢିଛି।
My humble submission, my lord, if a accused person avoid the notice,
ଆରେ sir, it is not that.
Supreme Court direct.
ଆରେ ଆପଣ don't voice your raise, ମୁଁ raise କଲେ ତ କାଚ ଭାଙ୍ଗି ଦେବି, ସେଟା କଣ ଅଛି କି? Please wait. Aare I'm asking you para 35 ରେ when you deny that I do not have any knowledge.
ନାଇଁ ମୁଁ I have bounce check ର ମୁଁ notice ତ ନେଇଛି ନା।
ଆପଣ ତ again divert କରିବେ ଆଉ।
ମୁଁ ଆପଣ ଯାହା କହୁଛନ୍ତି ମୁଁ ବୁଝୁଛି ଆଜ୍ଞା।
ତାହେଲେ answer that.
ହଁ ମୁଁ ସେଇପାଇଁ କହିଲି।
Answer that.
Once a notice issue, it deems to be not sufficient notice.
Yes, you conclude your argument. Adjournment କେବେ ଚାହୁଁଛନ୍ତି? When do you want the matter to be adjourned? When do you want?
1 week after. Any day.
December na January?
January.
The learned counsel for the petitioner, after arguing for quite some time, has prayed for adjournment, adjourning the matter. When it was specifically asked regarding the paragraph 35 of his cross-examination in the 1cc case number 82 of 2018, wherein the complainant petitioner has stated, page 28, para 35, quote kar dele, para 35. It was also specifically deliberated in the court that in view of the provisions contained in section 138
B,
proviso B, whether after the complainant himself states that he cannot say whether the accused has knowledge of bounced check or not, the court can proceed with the matter. The learned counsel for the petitioner submits that since the accused appeared before the court after notice being sufficient as per the summons of the court, the paragraph 35 of the cross-examination of the complainant has no further relevance. Para. As prayed for, list on kebe date kale?
22
22/1/2024.
On behalf of Mr. Nandi, lets me to come 2 weeks after.
Your name, madam?
Yes,
Apanko naada koibe?
Gayatri Das.
Miss M.S. Gayatri Das on behalf of A.S. Nandi for the petitioner, Mr. the S.S. Mahapatra A.C. for the state. Learned counsel for the petitioner seeks further accommodation to advance arguments. To grant further opportunity as prayed for, Opposite to the petitioner as paid for list on 8th of January. 8th of January 2024. Yes, next.
16.
भूल डिसेंबर हो जाइतला सेटा आनिले
Your Lordship may kindly be.
काली रे लेफ्ट ओवर कितना रहला पांच पांचटा कर दियो ऐड कर दी परिवे आपण जो नुआ स्टार्ट कर दी कर दो ना कोन अछि माने फेरिले ना रखि छथि 70 पांच पांचटा ऐड कर दियो 12 टा केते थर चारटा ऐड ले 3 दिन नहीं जो yes
I may be apologized, my lord, due to my item was my lord 12, which was passed over to my lord.
Sir, there is no practice of intervening during a court proceeding, sir. There is practice followed that somebody will stand up like Jack out of the box and start saying something. It's not part of this. So, since there is no, you have to understand that. There is no, you can check up with the, if it is their life, then they might be knowing the order. I understand you are at a distance and you are in virtual court, you might be having anxiety, but still then you have to wait. You can't interject in between a proceeding.
Yes, my lord, I may be.
Then it becomes so casual. I mean, this digital format has this disadvantage because we are disjoint from our surrounding. It's not exactly a court proceeding. So be patient, wait.
Yes, my lord.
All the matters are again passed over to be taken up at 2 p.m.
Yes, my lord.
Whenever their counsel is not appearing and there is no objection from the other side, they are not objecting. In some cases, informant is there. So it is again called again at 2 p.m.
Yes, my lord. I make it.
Initially, I thought that it is your matter. Then I see Mr. Jena is standing. Your colleague is standing in the court. So he is also unable to understand. Yes.
My lord, on behalf of Mr. Sahoo,
on
behalf of Mr. Sahoo, my lord.
Asit Kumar Jena, on behalf of M.S.Sahoo,
my lord.
For the petitioner.
My lord, this is a case of 20B2C.
Yes.
And section 2529 of the NDPS Act, my lord.
Yes.
I am in custody since 9/4/2023, my lord. An allegation against me is that, my lords, that on the date of alleged incident, my lords, while, my lord, the informant and staff, my lord, performing the patrolling duties, my lords, that so for the quantity is concerned, my lord, that is
30 kg.
My lord, 30 kg, my lord.
Past allegations?
No past allegations.
Two criminal antecedents.
Of similar nature.
Yes. MD Shorab, my lord, Hon'Ble PS case number 388, sorry, my lord, 388 of 2022 under section 457, 380, and Hon'Ble PS case number 350 of 2019 of 374 and 375 of IPC.
And co type of offense,
property. 380, my lord, theft.
Property.
274, 75, my lord, with regard to adulteration, food adulteration, and all
that is life, my lord.
Life conviction.
As for Odisha amendment, life.
Food rate.
Yes, ma'am.
But what about Ganjai adulteration? If somebody sells adulterated ganja, then I think that should have some consideration. Kete boysa kete?
My lord, so far age of the petitioner is concerned.
Mr. Jena, can you not file that affidavit?
My lord, he requested me.
So, upon seta tanko advise karibe na. He may be, I think, he is younger to you. You are senior to him, so you should advise that.
In fact, my lord, he instructed me.
Once that has become a norm now, as far as the proceeding here in Odisha High Court is concerned.
He informed me one thing, my lord, that in the meantime, 180 days closed, my lord. And
he has complied with the orders.
My lord, he has surrendered, my lord.
Surrendered. I mean, there is no adverse inference against him.
No. And so far, my lord, the charge sheet is concerned, my lord, that charge sheet is yet not been filed, my lord. Though
That
one,
instruction, it was adjourned for on 16/11 for that only.
my lord. And
Haji, Mr. Sahoo has
no,
told you.
charge sheet not been filed, my lord.
Mr. Mahapatra?
My lord, I have not received the up-to-date case diary. Case diary is
So you
received, my
obtained
lord.
up-to-date case diary?
I'll
You
be
also
getting.
filed that affidavit indicating his past allegations, whatever you are getting.
Yes, my lord, preliminary, sorry, my lord, I am sorry. My lord, the preliminary charge sheet filed, my lord. That has been filed on. Yes, ma'am. That has been filed on 15th October 2023. My lord, under section 20B 2C of NDPS Act. Preliminary charge sheet has already been filed.
So without that affidavit, can his prayer be considered now?
No, my
Because
lord,
he has a criminal proclivity.
he has criminal antecedents. He has to
So
explain
say
that.
that, no, Mr. Jannah is not aware also. Mr. कौन लिख ले? Appearance लिख ले. Mrs. Mahapatra लिख ले. The learned counsel for the Mr. Jannah, learned counsel for the petitioner submits that as he has been instructed by the Mr. Sahoo, who was appearing for the petitioner, he doesn't have exact instructions regarding the whether consider FPR, whether final prosecution report has been already filed or not. The learned AAC submits that in the meanwhile.
That has been filed.
15th
October.
The preliminary prosecution
Charge sheet
report has
has
been
been
filed on.
Keeping investigation open, madam.
Giving investigation open on 378.
173.8.
173 clause 8.
173.
Clause 8.
173 into bracket clause 8.
Of CRPC.
It is further indicated that it is further submitted by the learned counsel, additional standing counsel, that there are some past allegations of criminal activity against the petitioner. The learned counsel for the petitioner submits that he shall file affidavit on behalf of the petitioner indicating the past allegations of criminal activity, if any, after obtaining the said instructions through any of the relative of the petitioner. How much time, Mr. Jannah?
My lord, 2 weeks time may be granted.
2 weeks time upon nebe atal kon apon enti kori gode palela apankar chutti hei jibo
by next week.
Anyway, total अछि आज्ञा 2 सप्ताह अपन 2 weeks time मागचंती नहीं सॉरी गोटे कैलेंडर रे फोल्ड हे जाइछ मते देखा जोनी
by next week your lordship.
We shall file the affidavit by 8/12/2023. Copy be served on the learned AAC for the state, learned counsel for the state. List on 15 na 18
Well, 15.
List on 18/12/2023.
Since the copy ta de dile in time, it will be.
Se to dou nahanti agya to mane court is prodding that apon eta kahi ki dou nahanti jodi if it is a norm. I am not. In fact, once it has started, these orders have been passed by the earlier benches. That is still just being continued. Yes. And in your case, Mr. Jannah, there is no similar allegations.
Man.
Have you heard? Did you mark that?
Man.
So you should have done that. In NDPS cases and in this hooliganism 307, usually these affidavits are sought for.
Man.
And maybe, you see, the changing of the counsel is a problem. On 11/10, he changed the earlier counsel. The new counsel did not have the instruction, perhaps. Dekhle? 18/12 kar dele. Theek ache. 17.
May I please, your lordship?
Yes.
Sir, my lord, allegation of 20B 2C NDPS Act, my lord.
Yes.
And the FIR was registered against unknown persons.
Yes.
Prosecution case is that, my lord, on the date of alleged incident, my lords, the informant and the staff, my lords, were performing the duties, my lord, perpetrating duties, my lords. And while, my lord, doing such duties, they saw that, my lord, 3 motorcycles are standing and some persons are there, my lords. Accordingly, they rushed to the spot, my lord, and seeing the police personnel, my lords, all the accused personnel fled away from the spot, man. This is the, my lord, the prosecution case as per the, my lord, the FIR, my lords. And the ganja was seized, 3 packet of ganja was seized from the 3 motorcycles. And some packet was, my lords, seized from the land, my lords. And accordingly, FIR was registered against unknown persons, my lords. During the course,
motorcycles were abandoned. You mean to say?
No, not abandoned, my lord. Allegation is there, my lord. Some persons are there, my lord. Seeing the police personnel fled away. Abandoned, my lord.
Sir, motorcycle came to abandon. It was a moving vehicle or a static vehicle?
Standing vehicles, my lord.
Static vehicle.
Standing vehicles, my lord.
Okay. Static, not
No.
standing.
And my
Human
lord,
being can stand. Okay, anyway.
My lord, in 3 motorcycles they were transporting. It was in moving condition.
Exactly.
Having seen the police, my lord, they fled away.
They parked the vehicle and fled away.
My-
That is your case.
and my lord,
He's almost saying the similar thing, but on the spot, what happened thereafter?
Yes, ma'am.
So obviously the vehicles were standstill,
Yes,
packets were there,
yes, ma'am.
and some persons fled away.
They fled away.
and my lord.
Then
the-
how do they connect with this person?
Yes, my lords. That is I am coming, my lords.
Hmm.
During the course of investigation, my lords, they only made a supervision report that we are the accused in that case, my lords. Accordingly, my lord, one of the accused, the present petitioner was arrested from his house, my lord. From his house. And his statement was recorded. And in that statement, I confess that I, along with other co-accused person, committed the offense, my lord. This is the allegation against us only.
That statement is made to the police.
Before the police, my lords. If your lordship will permit me, I will read it.
No, I don't have to because he has
Yes,
to respond.
Yes, my lord, I am holding my.
Since
His
at
confessional
times I'm finding that
Pardon.
no, but not in your case. The lawyers are thinking that the judge has to respond. He has to respond.
No, my lord, the confessional statement, based on the confessional statement, police started the investigation. And
No, no.
they are
Confessional court hela.
my lord.
Confessional mane statement, self-inculpatory statement
Yes, my lord.
is inadmissible if made in.
No, that is, my lord, that is with regard to proceeding the investigation. My lord, what I am submitting, after his confession, his
Hey, where he confessed?
my lord, he confessed before the police.
Police first after seizure of that material went to his house.
Yes, yes.
He has been arrested there. Then he was in custody.
Custody. My lord,
Obviously.
when custody, my lord, that part is, my lord, his confessional statement, we are not, my lord, on that because that is settled law, the confessional statement before the police, my lord, it will. But incriminating material, what has been seized from their possession, my lord, their phone numbers, but the phone as well as the mobile numbers, SIM cards.
No, contraband possession, how you have.
Contraband possession, my lord, that with regard to, they were not in possession of that immediately. But the material seized, my lord, the phone and the SIM card seized, my lord, the CDRs were recorded. That has been, my lord, well established. They were in regular, the 3 persons, the 3 persons apprehended. They from their mobile numbers and SIM cards, it has been found, my lord, they were in regular touch of the, my lord. The material seized, my lord, the CDRs and their activity and their confessional statement, my lord, it is not for them, my lord, the confessional statement, its veracity, its acceptance or not acceptance, it will be decided at the time of trial, my lord. It is not, it requires, my lord, while adjudicating a bail application, it requires whether prima facie case is there or not. Basing on their statement,
Upon the prima facie nahi, possession nahi.
possession, my lord, with regard
See,
to,
Mr. Mahapatra, I understand. I did not ask that question that day.
my lord, my lord.
So, Jenna, possession the theory, legal concept kona?
My
What is
lord,
the legal concept of possession?
My lords, the conscious possession means, my lords, that the accused must be,
That I understand.
my lord,
That I understand the conscious possession, that is your argument. It define hitabo
my lord,
NDPS re
my lord,
from conscious possession.
my lord.
But possession the ingredient kona?
My lords,
Possession, my lord, passive possession, my lord, also includes the attract and
Say, that
NDPS.
because it is argued that 3 quintal of ganja
my lord.
was not in possession of somebody.
Yes, ma'am.
But can it be said that 3 quintal of ganja is possessed by someone? So obviously it is a laughable proposition.
That is why, my lords.
So
Because
Mr. Jenna, corpus possessionist and animus possessionist.
Yes, ma'am.
So
Yes.
animus possessionist is important. Corpus is not that important.
And so,
କିନ୍ତୁ ଆପଣ କହିବା କଥା ଯେ ସେ କହୁଥିଲା ଯେ ଜଙ୍ଗଲରେ ଛିଡା ହେଇଥିଲା 3 କ୍ୱିଣ୍ଟାଲ ଗଞ୍ଜେଇ ଥୁଆ ହେଇଥିଲା that case. But in your case you are saying that the when you were arrested
my lord,
there was nothing.
no, my lord, I was arrested on 9/5 and the ganja was seized on 11/4, my lord.
No, that I am trying to get an answer from Mr. Mahapatra.
My lord,
Yes,
my lord, passive possession.
9/5 there nothing was been seized according to you also. You check
No.
out.
That has been seized, my lord, the vehicle as well as the ganja, my lord, that was seized from the spot. They fled away.
No, who played away that you have no idea.
My lord, that,
You are saying they played away because you are appearing for the prosecution.
my lord, after
You are
investigation.
because you see that it will be too much for a court to infer.
No, my lord, I'm submitting
Because,
whatever available
Yes,
on
yes,
record, and
I
I'm
understand. And you see that there is the difficult part is that even there is a possibility that these persons fled away,
Yes, ma'am.
which is not witnessed by anyone.
My lord,
Which is not witnessed by anyone.
my lord.
So that part is what you call that has been clouded.
There is a
Fine.
there
But
is a
but on 11/5 what was seized that I am asking you.
their mobile number as well as
NDPS रे मोबाइल नंबर देखंतु कोन हबो
mobile number, my lord.
पर्पस की एनिमस पोजेशन इज
Yes,
आपण
sir.
कोन देखेबे NDPS रे
NDPS रे lordship kindly have
से एडा मंडे को रखी परिबा
My
बिकॉज़
lord.
ऑलरेडी हमर आज
Yes,
बहुत
yes, lordship kindly have accommodation for me.
to भाई, my lord.
यस मु काई नंबर ता पचोची मु जानि पड़नी एक्चुअली एथरे तो किछि रेफरेंस नाही किंतु ओसे फाइल ता छोटो हे जिवो 6205 Mr. Asit Kumar Jenna for the petitioner, Mr. S.S. Mahapatra, AC for the state, the learned counsel for the petitioner submits that the petitioners were arrested from their home on
9/5.
9/5/2023, whereas the allegations of the contraband being seized
11/4,
on a road,
my lord.
on a road kept in 2 motorbikes,
3,
in 3 motorbikes on 11/4/2023.
23.
It is therefore submitted by the learned counsel for the petitioner that there was no conscious possession of any contraband when the petitioners were allegedly arrested as a matter of fact on
Pardon,
kebe arrested
9/5/2023.
It is further submitted by the learned counsel for the petitioner that the FPR final prosecution report has been submitted on
My lord, charge sheet submitted on
so and so date. The learned additional standing counsel, after addressing certain arguments,
my lord 24/10/2023.
seeks further accommodation to obtain instruction and advance arguments.
Well.
In response to the submissions of the learned counsel for the petitioner. 24/10.
24/10/2023, my lord.
24/10/2023. And if I have understood correctly, actually, even I cannot go into those aspects by which may prejudice your case or their case.
No.
Kotoda kohunanti ki kain charge sheet file kale, kothre file kale, mu can deal ebe kari 439. I cannot go. I can simply say that these are the submissions and kebe chahunchandi
Next, my lord, Monday or Tuesday.
okay.
Tuesday.
6th re asu
6.
6/12.
Ma'am.
Mr. Jenna 6/12.
My lord.
Yes.
My lords, next item, item 18, connected method. Same order, only the rate of custody, my lord, 22 5.
22 5 ରେ arrest ହେଲେ
He is
ସେ
having,
କନଫେସ କଲା ପରେ ୟାଙ୍କୁ ଉପରେ ବୋଧେ
Arrest
he is having, they laid, my lord, leading to discovery statement was recorded and they laid, they made recovery of the mobile. Their statement recorded on section 27 of the
because then it becomes so difficult actually.
my lord,
In so one case, a victim has been there for 7 years
my lord.
in custody, almost 6 years. Mr. Standing counsel, Mr. Naik, they were appearing.
My lord.
After reinvestigation, also we are stuck with the mobile.
Yes.
Mobile रे आपण conscious possession रे कौन correlate करिवे?
No, no, my lord.
आपण कहउछन्ती जे they are part of that gang who those who are transit.
That is
there. But
and that is
mobile रे से कथा होउथिले आपण केमती how is it proved? Because Mr. Mahapatra, then it sends a dangerous precedence.
Two of the
Suppose somebody takes his mobile, makes a call, and says that I am having 20 kg of ganja, and the court will take cognizance. Just imagine what will be the. So that is how, because as a constitutional court or court having jurisdiction, supervision of the lower courts, we are at times setting dangerous precedents. And why the Evidence Act is still very less in the amendment? Because you have to produce the best. Upon a direct evidence, the mandate is you have to produce the best evidence of possession.
Yes.
Next matter re apanakara
one criminal antecedent
18 re ଦେଇଛନ୍ତି affidavit ଦେଇଛନ୍ତି ଦେଇ ଦିଅନ୍ତୁ ଯୋଉଟା करे ଦରକାର ଆପଣ affidavit ଦିଅନ୍ତୁ.
One criminal antecedent. Second,
ମିଥୁନ ଦଳ ମିଥୁନ ଢାଲି ଏଟା ସେଇ ମାଲକାନଗିରି ହେଇଥିବ
ମାଇଲ
ଏଥିରେ ଡେଟ୍ ଅଫ ଆରେଷ୍ଟ କହିଲେ ଯେ ହି ୱାଜ ଆରେଷ୍ଟେଡ
22/5/2023
ଗୋଟେ 11/5 ରେ ଆରେଷ୍ଟ ହେଲେ ପ୍ରଥମଟା
9/5
ରେ ସରି 9/5 18ଟା 11/5 19ଟା
नो माय लॉर्ड 17 टा होची 9/5 18 टा
नेक्स्ट दिटा मैटर कहले मोबाइल
ना नेक्स्ट गोटे मैटर 18 टा होची 22/5
यस सेम ऑर्डर यस
19
Lordship, kindly taken up the matter after one.
You are Mr. Hassan
K. Behera.
Mr. K. Behera, on behalf of the petitioner, the learned ASC for the state, learned counsel for the petitioner 68 for further accommodation to advance arguments. As prayed for January na December ke be chahunchandi?
It's January.
January. As prayed for list on 17/1/2024. Yes, next.
He is having one criminal antecedent. He may file.
Wherever, sir, there is a criminal antecedent, you complete. Don't wait for the court to ask you.
That's it.
Upon affidavit करके solve करंतु.
20.
My lord, pray for 1 week after.
Mr. You are Mr. Korno. I'm sorry.
Ranjan Dongri.
I'm so sorry.
Ranjan Dongri.
Mr. Ranjan, microphone ne कौन आंती?
Dongri, D-A-N-G.
Mr. D-A-N.
On behalf of Mr.
I remember your face, even your name also, but always I may not be particular in recalling. Mr. Ranjan Dangri on behalf of J.K. Ponda for the petitioner. The learned adjournment is sought for on behalf of the learned counsel for the petitioner to advance arguments as prayed for list on after vacation. Yes. 18/1/2024 to grant further opportunity to the petitioner. The learned AAC reiterates his submission that case diary has been made available. Yes, next.
21.
21, my lord, the brief has been transferred from me. My name may be deleted.
Mr. Mohan Kumar Sahu for the petitioner.
Vitas Kumar Swain.
And 21 after loss, my lord.
Mr. Vitas Kumar Swain.
Yes.
Under Mr. Sahu.
Vitas, BITA says Vitas Kumar Sahu for Swain.
Yes.
For the petitioner, but it Mohan Sahu kora naata achi.
Ashok Sahu.
अरे सर से कहउचंती this is item 22 ta
21 time after loss
mu 22 देखुच mu I was looking at another brief. Please wait. Mr. Vitas Kumar Swai submits that the brief has been transferred transferred from him, and he is no more appearing in the matter. Name of Sri Swami be deleted from the cause list as well as the case brief. The name of Mr. A.K. Sahoo and Associates has been indicated as the fresh set of counsel appearing for the petitioner. Adjournment is sought for on. I'm sorry, it pass over 2 p.m. 2 p.m. Yes, to be called again at 2 p.m. Yes, 22 Mohan Sahoo. Mr. Asit Kumar Jena on behalf of Mohan Kumar Sahoo for the petitioner.
1 week after.
The learned counsel for the Chutti Purvu na pore chahunchun.
Chutti Purvu.
The learned counsel for the adjournment is sought for on behalf of the learned counsel for the petitioner to advance arguments as spread for list. List on 21, 12, 20, 24. I'm so sorry. 20, 23. The learned AC submits that
Available.
case diary is available. Yes.
23.
May I please, your lordship?
Yes.
Allegation of 394 IPC, section 25, 27 of the Arms Act, my lord.
Yes.
And I am in custody, my lord, since 19/6/2023. Incident, my lords, as per the affair,
past allegations?
My lord, I have having the past allegations, and I have already, my lords, filed the, my lord, the affidavit, comprehensive affidavit to that effect, my lord.
7546. Dita matter achi?
My lord. 7546.
76546, yes.
My lord. I have already filed, my lord. And noting is there, my lord, that I have already filed a copy of the, my lord, complaint affidavit regarding the
They are in custody. What the affidavit they have filed?
The connected matters, Sudhanshu Gowda, Umacharan Gowda, Sanatana Gowda, that is the same affair or the different affair?
Different affair, my lord. No. So far this case is concerned, 3 petitioners before your lordship in this bail application.
No. I'm just kindly mark the bail appeal number. 7136, 7139, 714.
In respect of the another affair, my lord.
That is sure.
My lord.
Your FIR number is?
So far the 7136 is concerned, my lord, that is, my lord.
No.
This affair.
Exactly. Your mane,
that is, my lord, PS case number, Soroda PS case number 235 of 2023, my lord.
235? Separate incident?
Separate incident.
All are separate.
Separate incident, my lord.
That is, yes, Suruda PS case number 265.
My lord.
Okay.
And we were arrested in that case, my lord, remanded in these 2 cases.
It is remanded,
my lord. An allegation is that, my lord, that snatching away, my lord, the mobile phone and necklace, my lord.
No. Yes, my lord, in the present case, my lord, upon leading to discovery by the present petitioner, my lord, the gold.
Not pressed korunandi. Upon reject aratare.
My lord.
It is labho kon hobo press kori.
No, it is separate
strategy. I'm just thinking aloud.
What I humbly submit, my lords. This is a separate case, my lords. And so far,
I understand.
My lord.
Examine kali case number pacharli, PS case verify kali. ଆପଣଙ୍କୁ କହିଲି ଦେଖନ୍ତୁ ନମ୍ବର କହିଲି
ଏ ଦିଟା ଯେହେତୁ ଟ୍ରାଏଲ ବାଇ ଜୁଡିସିଆଲ ମାଜିଷ୍ଟ୍ରେଟ ଫାର୍ଷ୍ଟ କ୍ଲାସ ଏଥିରେ ଦିଟା ଯେ ବେଲ୍ ହେଇଯିବେ ସେଟା ପୁଣି ଆଉଥରେ ସେପଟେ ମୁଭ୍ କରିକି ଆସିବି ସେଠି ଯଦି ବେଲ୍ ହେଇଗଲା ମାନେ ରିଲିଜ ହେଇଯିବେ ଏଥିରେ
ଆପଣ ସେ ଚାନ୍ସ ସେଥିରେ ନେଇଥାନ୍ତେ ସେଥିରେ ରିଜେକ୍ଟ ହେଇଗଲା
that matters.
Those 3 cases it has already been rejected by the coordinate bench ଆପଣ ସେ ଚାନ୍ସ ଟା ନେଲେନି ସେଠି
May I place one thing, my lord?
Yes.
In that case, what happened, my lord? This petitioner have been identified in TI period, my lord. And according, my lord, in this case, my lord was pleased to direct.
Those orders are staring at me also. Even if it is a separate FIR, but I cannot apply different standards.
Your lordship may deal separately, man. If your lordship,
I understand, but how will I apply different standards?
Because, my lord, in this case, we are not identifying TI period, my lord.
Mr. Jena, Mr. Bujina. ଆପଣ କଣ ଏମିତି ଆପଣ ବୁଝିବାକୁ ପଡିବ? Can the court say that there is a criminal proclivity, so bail should be granted? Yesterday, that was the discussion. Once there is a criminal proclivity and there is a serious allegations against the particular petitioner, bail has been rejected by this court. You are saying that there it is 10 lakhs and ornaments, here it is other smaller. So how does it make a difference? Upon the person is not getting bail. Rather, you should have taken chance fast here. I don't know who are the age of matter. Upon it, say petition 7546. They were filed much after. As a lawyer, what you can do? Whenever it comes to you, will file. So they were filed 7136. That is lock of the petitioner. You think about it.
Take instruction and charge sheet.
Whatever, sir. It's not, but I think that you should also think that order taking into his criminal proclivity, the bail has been rejected. Only thing is that you are saying after they were arrested in those matters, they have been forwarded in these matters. So how does it improve the case? It doesn't improve. Yesterday, one matter after the affidavit was filed, the prayer is that the bail should be considered. So they will respond. Unless they respond, can they pass an order that since the petitioner has a background of criminal activity, he should be granted bail? Rather, it is the other way around. If the petitioner has passed criminal allegations, bail has been rejected, then how a subsequent bail can be granted? And what for also? Perhaps instead of going into merits,
only in case
you can withdraw it.
My lord,
and it's a valid prayer. You will say that since already the bail has been rejected in the connected matter, right now I do not want to press this matter. See, no, it's not that you are avoiding. It's not that you are avoiding. You see why the bail is withdrawn and dismissed. Because there is a possibility that merit disposal will amount to a future problem. Once the court rejects on merits, observe certain things, it will come in the way of getting future, but after in change circumstances.
But in this case, my lords, your lordship directed specifically to call for a report regarding TI period, my lord. Because the only difference between that case and this case is, my lord, that in that case, my lord, TI period was conducted, accused person were identified, my lord, and on that ground, my lord, this honorable court was inclined to reject the bail application.
That is a matter of luck.
Yes, my lord.
But now where the petitioner is standing. His bail has been rejected. All three bail have been rejected. 2 bail applications are pending. After rejection of the bail in the serious occurrence, he is trying to get bail in the other offences. And the allegations are similar. Kotri mobile phone chhodele, koti 10 lakh tanga chhodele, koti chain chhodele. That distinction you are making. For grant of bail, that makes no sense because already there is an allegation and the bail has been rejected.
May I pray one thing, my lord?
You take your time. Since it come to my mind,
my lord,
and somehow I have now become more conversant with all of you, I am sharing my thoughts. You take time. I have no problem. They never object that kahin bail adjournment douchonti. Seta to kebe honi na. Ikke Jenna, as far as state is concerned, Ikke Jenna for the petitioner, Asit Kumar Jenna, Mr. S.S. Mahapatra AC for the state, Learned Counsel for the petitioner seeks accommodation to obtain instructions and advance arguments. Kebe Mr. Jenna?
My lord,
तीनटा वीक अच्छी आउ नाही तीन लास्ट डेट छाड़ दियंतु समुदाय तीनटा सप्ताह अच्छी आफ्टर वेकेशन 18 जनवरी 2024 both the matter same
man. Grateful, lords.
Yes.
24.
To be called again. Next.
25.
Yes, Mr. Mahapatra.
Yes, my lord. Next page, my lord.
Yes.
Last occasion, state has taken an instruction over the affidavit whether I have filed an affidavit. The father of the petitioner has filed an affidavit, lordship. Actually, the petitioner is in custody, my lord, on 2/6/2023. It's that internet phishing case, my lord. The account of the petitioner is used.
Accordingly, yes, Mr. You have sought copy, Mr. Mahapatra.
Yes.
Both Mr. Mr. S.S. Mahapatra.
24.
This is item, Mr. AC. This is item 25.
24.
7722.
24 urgent.
24 to be called again. Passed over. To be called again at 2 p.m.
Yes, yes. In that case, he had filed affidavit, my lord. There is 7 lakhs of, my lord, misappropriation. He has filed affidavit of furnishing Casualty of rupees 1.5 lakh.
Surety no, এটা deposit
Lordship,
ro.
it
সেটা
is up
deposit
to
ro
your
condition যাହା ରହୁଛି ro.
Yes, yes.
সেটা ଗୋଟେ interest bearing SDR ରେ ରହୁ
Lordship.
with auto renewal clause.
Yes.
And it will shall abide by the final orders that would be passed. And local surety will be there.
So the father will be
One family member, one local surety.
obliged.
যাହା সেই condition সেটা সেଠି decide হব.
আগে
The Mr. Vidyalok Mahapatra for the petitioner, Mr. S.S. Mahapatra, ଆପଣ ଏଟା affidavit by counsel ଲେଖି ଦଉଛନ୍ତି.
ନା affidavit ତା ବାପା ଦେଇଛନ୍ତି.
ତାଙ୍କ କୋର୍ଟ କଣ ବୁଝିବେ? ଆପଣ ମାନେ ଯେ ଲିଷ୍ଟ କରୁଛନ୍ତି, I don't mean you in person. Mr. S.S. Mahapatra, AC for the state, the learned counsel for the petitioner submits that the petitioner is aged about
Petitioner is aged about lordship 22 years.
22 years, is in custody since
Custody since 2/6/2023.
2/6/2023. The final prosecution report has been submitted on
Submitted on final charge sheet
Final charge sheet.
6/10.
on so and so date. Investigation open ରଖିଛନ୍ତି ନା final
Submitted.
open?
That has been
The keeping the investigation open, PPR କରିଦେବେ. Preliminary prosecution report has been filed, keeping the further investigation open under section
on 28/7/2023 में.
28/7/2023. But it is further submitted that considering the age of the petitioner, he may be given a chance to come back to the community and lead a life along with the society that will help in reforming him. Para. The learned counsel for the petitioner refers to the affidavit filed by the father of the petitioner dated 13/11/2023, copy of which has been served on the learned AC. Para. The learned additional standing counsel referring to the materials contained in the case diary produced by the investigating agency and the nature of allegations opposes the prayer for bail. However, it is subpara. However, it is not disputed at the bar that the PPR has been already submitted on ete. Subpara, the learned AAC further submits that since the petitioner belongs to a neighboring state and has no local address for residence inside the state of Odisha, suitable terms and conditions have to be imposed by if the court grants bail to the petitioner. Para, the learned counsel for the petitioner submits that the petitioner shall subject himself to the jurisdiction of the learned court in session of the matter and shall abide by the terms and conditions that would be imposed for grant of bail. Para. Having heard the learned counsel for the petitioner, the learned ASC for the state, considering the material on record, the affidavit of the father of the petitioner dated 13/11/2023, and the fact that the petitioner is aged about 22 years and should be given a chance to come back to the normal social life that would help him to reform. The court is inclined to grant bail to the petitioner subject to the stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also include the following conditions. In those following conditions, there will be some further stringent conditions in the sense local surety, family member, cash, the mobile number, he has to remain active and all those.
Yes, Lordship.
Yes. The condition would ଆଣିକି ସେଟା କରିବାକୁ ପଡିବ ଯୋଉଟା already typed out ହେଇଛି ଅନ୍ୟ କେସ୍ ଗୁଡାକରେ. Yes.
Obliged lordship.
Disposed of accordingly. ତାପରେ ଲେଖିବେ in the condition ଛଡା ତା last para ଲେଖନ୍ତୁ Mr. Mahapatra that affidavit he filed before the affidavit dated 13/11/2023 copy of the affidavit
Lordship.
Dated 13/11/2023 filed by Mr. MD G. Ansari,
Gayashuddin Ansari, lordship.
father of the petitioner, shall also be produced before the learned court in session of the matter. The amount of rupees 1.5 lakh stated by the father of the petitioner shall be deposited in the registry na kon kwa jauchi
interest bearing account.
Cheda ta in the registry of the court.
Lion re deposit hobo STDR he ki.
Whatever.
Yes, lordship.
Whatever. Court that shall be made a se kouchuni or lekha jau short term deposit receipt STDR. That shall be made a short term deposit in a nationalized bank with auto renewal clause.
Yes.
The release of the amounts shall abide by the further orders that would be passed by the learned trial court upon disposal of upon the final adjudication of the matter.
Obliged lordship.
Yes. So rest of the matters after recess. Any mention? So what polele? Detail mention karo. Yes.
Item 38 may kindly be taken up for.
Bail, sir, I cannot, without passing order, I cannot do it.
Due to some of my personal difficulties, I may not.
Sir, my difficulty is that I have to dictate that order. Sir, how you can inform any of your friend, but upon jota koiba kotha. Mo apuno absence se order ta kenti dictate karibi.
Yes, my lord.
I am not pulling out any file.
No, my lord.
That list on Amco date. That I am not doing, sir. I have to pass that order in your presence. So Das, you are saying, sir?
My lord, item 26, next matter. Actually,
Yes, what do you want, 26?
My lord, interim bail is expiring on Monday. I have filed an extension for
No extension will be granted.
No, the genuine reason.
You surrender, then you file the PA.
My lord, his father condition is deteriorating day by day.
Whatever.
His father is
I told you that don't meet your father, he will deteriorate. I find myself to be prophetic. He's a heart patient.
Yes, ma'am.
Yes. I advise you do not meet him.
The doctor has advised him for a regular checkup.
Yes.
Division says,
Yes.
Only I'm praying for 15 days.
15 days as a 5 days or 15 minutes, I am not granting it.
So life could be saved, my lord. Mother also.
No, I'm rejecting it. I'm rejecting it.
No, let him come. After lunch, I'm satisfied.
No, after no adjournment. Yes, Mr. Bhuya.
My lord, there are two other brothers, one elder and another.
They are reject.
You see, that I asked him. He said that they are not living with family. I have this problem, Mr. Bhuya, since I have been a long-standing associate of you, that remembering things.
They are residing.
So even looking at, and Mr. Das was not the counsel. Mr. Raut was the counsel.
Raut was the counsel.
Raut was the counsel.
Recently, the brief has been transferred.
It will be transferred because to get further extension of interim bail.
Right.
So
let it come up.
You have already, most likely you are the cause of the heart condition of the father. So I told you that. You can check with Mr. Bhuya or Mr. Raut.
That is absolutely correct, I know.
No, I may be wrong. That is partly a advice towards you.
My lord, the pain and suffering which they have suffered, at least it could be
father. Sir, you are not moving the bail for the father.
No.
You are using your father as a pawn now to seeking bail.
Heart blockage.
You see how unfortunate.
Heart blockage against
heart blockage re apanଙ୍କର kon role अछि?
At least he could.
That is the other difficulty.
He could be there to save his father life.
He cannot.
At least for 1 week.
He cannot. A person who is having anoxia due to a blockage, he may suffer a heart attack being present with you. ଆପଣ ତାଙ୍କୁ ଷ୍ଟ୍ରେସ୍ ଷ୍ଟ୍ରେନ୍ ଦେବେନି ବ୍ଲକେଜ ହେଲେ କଣ ହୁଏ ବ୍ଲକେଜ ହେଲେ କଣ ହୁଏ
ମାର ବି ସେଇ ଅବସ୍ଥା ହେଇଛି ମାର ବି ସେଇ ଅବସ୍ଥା ଡକ୍ଟର
ଏଇଟା ଦିଅନ୍ତୁ
ମାନେ let it come after lunch.
1415 of 2023 at flag B, the prayer made for extension of bail. The petition this court is not inclined to, is considering the averments made in the petition. It is apparent that the petitioner is utilizing the illness of his father to extend where in fact being released on bail, he has not contributed anything towards the treatment of his father.
My lord contributed certificate there.
ଆପଣ କଣ କରିଛନ୍ତି certificate ଦିଅନ୍ତୁ।
Regularly ତା ବାପାଙ୍କୁ ନେଇକି ଯାଇକି treatment
ଆପଣ କେନ୍ ଯାଉଥିଲେ ତାଙ୍କୁ? ଆପଣଙ୍କର କାମ ହେଲା ଆପଣ ପଇସା ସୁଝିବେ।
ହଁ ପଇସା ବି
ସୋ ଆପଣ ବର୍ତ୍ତମାନ ବାପାଙ୍କୁ କହୁଥିଲେ ଯେ ପଇସା ଦିଅନ୍ତୁ।
ନା ନା
ତାହେଲେ କାହିଁକି why was then he suffering for that?
No, my lord,
you are adding to the ignominy of the father.
My lord, he actually taking his father.
Apparently, the petitioner is utilizing, though he has other family members like brothers to take care of his father. On the spacious ground that, on the spacious purported ground that the brothers are not staying with him, the petitioner is taking advantage of the illness of his father to extend the period of bail.
MC is under treatment, my lord.
If he is not getting, then he can file a petition. The WPC court will take care of his health. If he is a pauper, if he is facing difficulty, and then then he can get admitted. You do that.
I will file an affidavit.
You do that. Get your father admitted in the hospital, SCB Medical College. Court will take care of it. You don't have to bother about it.
Only son, my lord, they were looking at.
It is
at least their life.
It is also wrongly stated that the petitioner is the only son, whereas there are two brothers.
After the father and mother.
No, you have stated that. I will record, Mr. Das. This is not a drawing room conversation. So please don't make it that. Now we are live. We are live in YouTube.
Now
you are saying in so many words you said that you are the only son.
Only to look at
it is submitted by the learned counsel for the petitioner that he is the only son who is taking care of his health of his father. On the face of it, such statement is not correct. It is hoped that the father will be treated well by the other sons. You should have made them parties here. They should have filed that affidavit.
Man, I will file that affidavit.
No. Against whom you are making allegations? It is too late in the day. You are making allegations against your family members.
My lord had kept it to 15th for hearing of the regular bail application. My lord,
you are not listening, sir. Did I ask you when did I keep the bail?
No.
You are making allegations against the persons who are not on record.
I'll make
allegations of negligence.
I am extremely sorry.
In view of the above, the extension of petition for extending the bail is rejected. The petition shall surrender on completion of the bail period for interim. The period of bail, praying for interim, on the period of interim bail as granted earlier. The surrender certificate shall be produced by the next date. केवे सोरची आपण पीरियड टा
4-6-12
लिस्ट ऑन 8-12 8-12 एटा आईए टारे आईए रे मेन बीएलएपीएल रे करंतु the prayer for bail shall be the matter shall be adjourned, shall be taken up on 15-12 as directed earlier. एटा 8-12 रे आनी. Yes. Mr. Das, if he is listening to you, he should have advised you that how much he has managed to help the persons who are invested. How much money, Mr. Bhuya, he has taken away?
Millard, it is near about 17 crores, Millard.
Yes.
For giving flats, man.
Yes.
For giving flats. And he has only completed some of the flats up to 70%, Millard. After release for about 2 months, Millard, he should have made certain construction. So I have directed the IO to remain present.
Then you will see that I have talked to him before coming to court.
No.
You see, Mr. Das, it is not rocket science.
No.
With age and experience, we understand this.
Now
it is how true I was that you have started using your unfortunate father as a pun.
No, my lord.
The entire treatment is free in this state. If you are a pauper, surrender. Your father will be taken care of. He is a hapless person.
Mother is also suffering from
ତାଙ୍କର କୋଉଥିରେ ଆଜ୍ଞା ରେଷ୍ଟ୍ରିକ୍ସନ ନାହିଁ ଯେ ଜଣେ ଟ୍ରିଟମେଣ୍ଟ ହେଲେ ଗୋଟେ ଫ୍ୟାମିଲିରୁ ଆଉ ତାଙ୍କ କାହା ଟ୍ରିଟମେଣ୍ଟ ହେଇପାରିବନି
maybe perhaps my lord,
ଆପଣଙ୍କର ଯୋଉ ଆଞ୍ଜିଓପ୍ଲାଷ୍ଟି ଭଲରେ ହବ ମାଗଣାରେ
maybe by seeing the son they could get cured.
Sir, all these pleadings you should make before the client, not the court. ଆପଣ କୋର୍ଟରେ ବାର୍ଗେନ୍ କରୁଛନ୍ତି
ନା bargain କରି
Obviously,
only pleaded
obviously,
for
sir.
the life.
ଆପଣ 17 crores ନେଲା ପରେ ଯୋଉମାନଙ୍କର ଯାଇଛି ତାଙ୍କର କେତେ ଜଣଙ୍କର ହାର୍ଟ ଆଟାକ୍ ଆପଣ ଲିଷ୍ଟ କରିବେ ତ କାହାର କଣ ଡିଜିଜ ଅଛି ଆପଣ ଏଥିରେ ଗୋଟେ ଲିଷ୍ଟ ଦିଅନ୍ତୁ
ଆଜ୍ଞା No, I have directly.
କେତେ ଜଣ ଲୋକଙ୍କର କଣ ସଫରିଂ ଲୁକ୍ ଆଟ୍ ଦ୍ୟାଟ୍ ପିପୁଲ ଆର୍ ସଫରିଂ ବିକଜ ଅଫ ୟୁ ଆପଣ କଣ କରିଥିଲେ ଆପଣ ବର୍ତ୍ତମାନ now you are saying that it is ମୁଁ ବାପାଙ୍କ ଚିକିତ୍ସା କରୁଛି ମୁଁ କାହିଁ କାହାକୁ ଫ୍ଲାଟ ଦେବି
ନା ଫ୍ଲାଟ ଦବାକୁ ତ ମୁଁ ମନା କରିନି ମୁଁ ସପ୍ତାହ I will file an affidavit.
ଆପଣ you responded to Mr. Bhuya's submission that in 2 months you have done nothing.
ବାପା ମା ଦି ଜଣ
ମୁଁ ଆପଣ କହିଲେ ବର୍ତ୍ତମାନ
ବାପା ମା ଦି ଜଣଙ୍କ ବେମାର ତାକୁ ଛାଡିକି ଏଇଟାକୁ ଦେଖିବୁ କେମିତି ହବ ସେଇଟା ହଉଛି
ସେଟା ଠିକ
that is the pain.
ଠିକ ଅଛି 17 crore ନେଲା ପରେ ତ ସେଟା ବେଶୀ ବି ଆପଣଙ୍କର କନସର୍ନ ଡେଭଲପ କଲା ସେଟା ବି ହେଇଥିବ କଣ ଲେଖିଲେ ସେଟା ହେଇଗଲା ସେଟା 15 ରେ ଆସିବ ଏଟା ଆପଣ ସରେଣ୍ଡର କରିବେ 6 ତାରିଖରେ you will surrender on 6th surrender on 6th when the period is completed. The matter will be listed on 8th for production of the certificate or the order of surrender.
Surrender ଆଜ୍ଞା 4 ରେ ଅଛି surrender date.
ତ 4th ରେ କରିବେ on date of ମୁଁ ଲେଖିଥିଲି ସେଟା ବେଟର ଆପଣ ଡେଟ୍ ଛାଡି ଦିଅ
ଆଜ୍ଞା
ସେ ତାହେଲେ ପ୍ରୋବ୍ଲେମ ହେଇଯିବ the opposite party ଲେଖିବେ Mr. Vivekananda Bhuya, standing counsel
Special counsel
OPID along with Mr. Naik, Anil Naik, additional standing counsel. Yes.
Pardon, Your Lordship. Lordship, item 59, I seek for an adjournment, Your Lordship.
59, sir. ଦିଟା ବେଳେ କରିଦେଲେ ହବନି already we have taken time ସମସ୍ତେ wait କରିଛନ୍ତି. Yes. I have the advantage of going just behind, but you have to go to that place to have food. Here the learned counsel has become a judge. So that is how. Registry to send notice na kono. The private party bhitere registry state bhi kichi annathi.
That item 6,
Yes.
notice to the petitioner one. M.S.Sahoo.
Where is he? To grant further opportunity, none had appeared when the matter was taken up on 13/11/2023. To grant further opportunity, list on 9/1/2024. Registry shall intimate learned counsel Mr. M.S.Sahoo for the petitioner regarding the next date of listing. Yes.
Item 9.
9 it is.
May I please, my lord?
Yes.
Well, item 9, my lord, pre-prior adjournment, my lord, on behalf of the
Mr. You are Mr. Karna.
Yes, my lord.
This matter may
Puranada-
Vikas Karna, my
Mr.
lord.
Vikas Karna on behalf of Jugolo Kishore Panda for the petitioner. Mr. Standing Counsel for the state. He is again being adjourned since 2015.
Okay. From the date of filing.
Filing. As prayed for list in January.
It is
Mr. 24/1/2024
infructuous.
to grant further opportunity to the petitioner. The learned standing counsel submits that referring to the prayer made in the writ petition, as well as the averments, submits that the matter would have been rendered infructuous during its pendency for the last 10 years. Yes, next.
12.
9
So-
the
Same.
9 sub item ta bhi same karibe.
Same.
12 Mr. Mahanti. Yes, Mr. Mahanti.
Your Lordship may kindly be pleased as I have prayed for adjournment for 1 week, my lord.
Mr. Krishna Chandra, no, 1 week, then you will encounter vacation.
Yes, my lord.
There are average about 50 matters to be listed almost every day, specific urgent. So adjournment becomes a problem. Mr. Krishna Chandra Mahanti for the petitioner, Mr. S.S. Mahapatra AC for the state, learned counsel for the petitioner being present at the virtual court, High Court of Orissa, Mayurbhanj at Baripada, addresses arguments, learned counsel for the Tapar Sapara Karibe. The learned counsel for the petitioner seeks further accommodation to advance arguments. As prayed for, list on 29 January na nahi apna kon January early date chahuchunti
Early chahuchi sir.
12/1 na kebe
12
sei samar ko January gote kar diyo 12/1 date achi na chutti nahi achi 12/1
my lord.
yes
All right.
yes please
21.
May I please, your lordship, my lord?
yes
In this case, my lord, the petitioner has
Mr.
been-
P.S. Das for the petitioner, Mr. S.S. Mahapatra AC for the state.
My lord.
Upon जोड़ा का yes.
My lord, the petitioner has been implicated in the present case for offences under section 302 and other related offences. My lord, he has been arrested since, my lord, 12th June 23, my lord.
Sir, 12 June 23 रे आपण केमती आपण तो period of detention 302 रे होची life or death.
That is true.
But
So 10 years নহলে period of detention ର कोण अछि?
And also, my lord, in the case of 2016, my lord, they were absconding and they have been apprehended only in 2023.
That is true. Only, my lord,
And
the
trial has
allegation
already been stalled only for their apprehension. My lord. After their apprehension,
ସେଟା progress କଲାଣି କି? State has come to that, sir. कौन प्रोग्रेस करची सेटा
ଚାର୍ଜସିଟ୍ ହେଇଛି କମିଟମେଣ୍ଟ ଷ୍ଟେଜରେ ଅଛି।
ଆପଣ ତ ଶୁଣିଲେ that ଆପଣଙ୍କ ଯୋଗୁ ଏଟା ସେମିତି ପଡିକି ରହିଥିଲା। So 2023 ଆରେଷ୍ଟ ହେଲା ପରେ ଫର୍ଦର ପ୍ରୋଗ୍ରେସ କରିଛି।
Yes.
ଦେଖନ୍ତୁ it is up to you, but either you may not do not press it or you can adjourn it.
After commitment. Your lordship adjourn the matter.
The learned counsel for the petitioner seeks adjournment to obtain up-to-date instructions regarding the present status of trial. As prayed for list January 18/1/2024. The learned AC shall also obtain up-to-date instructions.
Yes.
Yes.
Status of the trial.
Around 24.
Item 20. Mr. Divyajyoti Sahoo for the petitioner.
I pray, my lord, 1 week after my lord.
S. Mahapatra AC for the state, learned counsel for the petitioner, 6 further accommodation to advance arguments as prayed for. List on 18/1/2024 to grant further opportunity to the petitioner. You have provided copies of the depositions.
Yes, my lord, provided the copy of the depositions.
I have gone through, but he
I
lost.
don't have copy. The learned counsel file करचंती की?
Yes, I have filed, my lord. I have just,
कोर्ट रे फाइल कर दीचंती?
yes, I have handed over to the council.
कोर्ट रे हैंडिंग ओवर केमते हो? कि मिस्टर बारिक नहीं जेचंती आपण ताकटो?
No, no, my lord, no, I have got.
अरे मु कोर्ट रे पचारचे आपण
No,
हैंडिंग
my lord, to court I have not filed. Government council I have filed.
तल मु केमती देखिबी?
Yes.
The learned counsel for the petitioner submits that he has served copies of the depositions of the PWs on the learned counsel for the state. The said copies shall also be filed for perusal of the court. Scanned copy be updated.
Yes, my lord.
Yes, Mr. Mahapatra, you are saying something?
No, my lord, here my lord friend may take when it is being adjourned to long date.
Up to date.
The depositions of other witnesses may be.
The learned counsel for the petitioner shall also obtain copies of the depositions of the PWs.
My lord. Examined so far.
Those have been examined
Yes,
so far.
But as per my instruction, only 5 witnesses has been examined till yet, my lord. If
देखो तो next
yes,
year.
my lord, yes, my lord.
Item 27.
Mr. Muhammad Ji Madani for the petitioner, Mr. S.S. Mahapatra AC for the state, Mr. Faiz, you are there for the informant.
Yes.
That's it. Mr. S.J. Faiz for the informant. You are Mr. Faiz or Mr. Haq?
Mr. Faiz.
Faiz. Sheikh Junaid Faiz for the informant. Yes, Mr. Madani.
The occurrence took place on 9/5/2023. Allegation under section 376(3)(506) read with section 4(2) of the Act, my lord.
Yes, there is.
Yes, ma'am.
Palli, Learned Counsel, you are through legal aid. Yes, sir. Legal aid. Krishna Palli, being through for informant oblique victim through no for informant oblique victim. Hybrid mode लिखिए. PALLI. आपण को गाँ को कौन कहती? हैं? गाँ कौन?
(164) statement.
Yes. The learned yes. The learned counsel for the informant oblique victim being present at the virtual court, High Court of Orissa, Raigada, addresses arguments. I'm sorry, your name is Mr. You are Mr. Panigrai?
No, my lord. D. Mahapatra.
Mr. D. Mahapatra. Full name is
Devidatta
Mahapatra. Mr. Devidatta Mahapatra on behalf of S.K. Das for the petitioner. Mr. Devasis Naik AGA for the state. Counsel for the petitioner six accommodation to advance arguments. As prayed for list on.
Because that notice is not yet sufficient.
As prayed for list on. January.
My lord.
10/1/2024 to grant further opportunity to the petitioner.
Obliged, my lord.
The para, then para, right further, order complete any. The learned AGA submits that he has intimated the concerned IIC to inform the victim oblique informant regarding their right of audience in the present proceeding. However, the response of the concerned officer is yet to be received. Para. The learned AGA shall again intimate the concerned IIC to inform the victim oblique informant regarding the right of audience in the present proceeding. Para. The registries upon file korchandi extra copy court re.
My lord, I'm on request, my lord.
Ei to problem upon instruction ta nebeni. Without looking at the cause list, don't never take that responsibility.
Recently,
Same thing kona court re hipariyo.
I beg pardon, my lord.
Pardon kona age. Kitna number item?
30.
30.
My lord.
Final
पण केबे फाइल कले से कॉपी टा
Extra copy filed, my lord, on 27/9/2023.
(27/9),
27/9, my lord.
office note doesn't indicate anything. Office note dated 24/8 कहil 15/12 नरे लेखुचंती copy not filed.
My lord, so far as the
Apana, can you do something positive for your petitioner or for your friend?
My lord,
You serve another file or another copy.
I'll do that, my lord.
कौन लिख ले? हाँ, तापर सपारा लिखंतु आ गोटे पारा नंबर नल करबे कि सपारा कर देबे. The learned counsel for the petitioner shall file extra copy of the brief in the registry within 2 days, within 3 working days, so as to enable the registry to send forward the copy to the learned court in session of the matter to inform the so that matter to hand over the copy to the informant oblique victim through the office of the court, and also intimate them regarding the next date of hearing, that is 10/1/2024. The secretary DLSA concerned shall be also intimated to provide legal aid to the informant oblique victim if they are unable to engage any counsel on their own. The learned counsel engaged for the petitioner can appear through the virtual court of the High Court nearby. Yes.
For the informant, my lord. Learned counsel for the informant, my lord. Last.
30.
My lord, learned counsel for it was dictated, my lord, for the petitioner.
I'm sorry. So, Sabu Jagar more petitioner here, they are now got acquainted.
My lord.
Legal aid provided to petitioner, legal aid provided to inform to the petitioner. So they are now it has gone to autocorrect.
My lord.
So now they are in autocorrect mode.
My lord. Obliged,
and the secretary is brilliant in autocorrecting things. Today he corrected the name of Mr. Pallai, because he likes Pallai.
Lordship, item 31, I pray for 2 weeks time, Lordship.
And the registry will return the file indicating that no, Pallai has not appeared. Then again it comes back. Yes, yes.
Lordship, 2 weeks time may be granted to filing of deposition, Lordship. In the meantime, Lordship.
Kete number time?
Item 31.
Number palela ye. Se jo tu kahi dele kon 31. Mr. P.K. Malik. P.K. Malik on behalf of
B.S. Das Parida.
B.S. Bhavani Shankar. B.S. Das Parida for the petitioner. You filed deposition of PW 1 to 4.
4, Lordship. Earlier we have filed.
Then
Then some of the witnesses have been examined, Lordship.
The learned counsel for the petitioner seeks further accommodation to obtain copies of the depositions of the PWs examined till date. File the same. Examined till date. Till date. Till date. Comma. Copy of the copies of the said depositions, if received, shall be scanned and the scanned copy be updated. If received, no, if filed, got it. The learned, yes. The copies of the depositions shall also be served on the learned AGA for the state to obtain, to enable him to obtain instruction. Yes. Kebe sir, January.
No, sir. Second week of December, Lordship.
Date करो second week coach. 20 12 23. 32.
32, may I please, Your Lordship?
Miss Salebala Jenna for the, you are Miss Jenna, I'm sorry.
J. Jenna, Your Lordship.
Miss J. Jenna, MS.J. Jenna for the petitioner. Mr. Devasis Naik, AGA for the state. Miss Radhasri Rautray for the informant.
But I have received a clear report from the IIC.
Yes.
There is threat perception.
Give that copy.
My lords.
$164 flag mark hichi.
No, it's there, it's folded.
ठीक है. AGA for the state. The learned counsel for the petitioner being present at the virtual court, Odisha High Court, Ganjam at Berhampur addresses arguments. She is working as a laborer in Bhubaneswar. That's the report. The report from the court in season is that the victim is working as a laborer in Bhubaneswar. No one is there in at village. You have to wait, Mr. Patnaik. The what likely? Order to the learned additional district judge, learned ADJ comes special court under POCSO Act Bhubaneswar through letter by letter number 3011/2023 addressed to the registry of the court has intimated the following. It likhi debe as the victim and her parent were absent to leki plea of the accused. Parjanta. In view of the learned AGA also submits that though he has forwarded the copy of the petition to be for handing it over to the informant oblique victim through the concerned IAC, he is yet to receive any confirmation of the same.
No, man. I have not received the CD in this case, so that was.
Notice is
No, notice
okay. Notice bhi paini. Pathe debe.
Again.
Para. In view of the fact indicated in the letter of the learned ADJ cum special court that the victim is working as a laborer in Bhubaneswar, the learned AG is requested to, if it would be possible to contact the victim to the police concerned and inform her regarding the right of audience in the present proceeding. Para. The secretary, the secretary DLSS shall also be informed regarding to provide legal aid to the informant oblique victim to be represented through a lawyer in the present proceeding. The learned counsel appearing for the informant and oblique victim can very well appear at the nearby virtual court of the High Court of Orissa. The Lord ADJ cum Special Court under POCSO Act Berhampur shall also be requested to make further efforts through his office for informing the informant oblique victim regarding their right of audience in the present court and the fact that they can appear anywhere being present at the virtual court. In January, Mr. Patnaik? January rakam. 17/1/2024. 17th January, Mr. Patnaik. Yes, by that time, hopefully, we were able to contact the
survivor, my lord.
37. Yes, please.
My lordship, last occasion, my lordship directed to the additional standing counsel to submit bank declaration or other documents before your lordship, my lords.
This is 9461, sir. Kailash Deori alias Hari. Apanako case number ta kete ki?
9461. SK Rahmat and Dula Bibi.
Say hospital le rahile chikitsa hele, but there is no statement, no indication. Say matter ta ta?
My lords.
Purba matter case diary ta Mr. Naik.
My lords.
The previous matter, you said that you are yet to receive the case diary.
My lords.
Mr. Patnaik appeared from Berhampur. The Purba matter would line add kar diyo to sir. The learned AGS will obtain up to date case diary. Including statement of the victim under section 164 of CRPC if recorded. Mr. Naik, there is a order dated 22/11, paragraph 2. So have you received any instruction?
My lord, my instruction says that nothing has been recorded. Although she was treated, nothing has been recorded.
It's very mysterious.
That is how it is, my lord. I will have a discussion.
I think if you check, I think it was only 60% burn.
Yes, my lord.
And it is below the chest. So she would have been fit to talk. Somebody has been burnt at the face.
My lord.
Even they can use this. He can if she writes something.
My lord. My lord, give me some time. I will have a discussion with
Mr. N. Thank you, Mr. Behra. That you are on track. You remember the case. That's a good thing. That saves time, and also that impresses the court that the lawyer is very particular.
My lordship, there is no single evidence, my lordship. My same submission is.
Sir, that's the problem. You may be getting acquitted. But I can't look the other way when these kind of cases. How there is no evidence? How the court will look the other way?
My lordship, investigation should be completed with beyond a reasonable doubt, my lordship. But in this matter,
investigation no. Are seta to apna standard of proof katha kouchanti.
My lordship.
But what is the what you see, everything sees the victim is present, everything is there. Then why there is no investigation? So the court will know. Who else will know that? Try to know rather.
My lordship, accused number 2 is a lady, my lordship. In a previous date, my lordship, 52 years, my lordship.
No, committing that. Then have you seen that movie Perfect Murder? Then there is nothing called perfect murder. You see, you cannot submit that since there is no evidence, so he should be acquitted. I mean, he should be granted bail. It is a matter of investigation now. Then what is very unusual is that there is no evidence. So that I'm trying to find out.
My lordship 7 ମାସ 8 ମାସ ହେଇଗଲା ଗୋଟେ ଫ୍ୟାକ୍ଟ ବି ମାଇ ଲର୍ଡସିପ ଗ୍ୟାଦରିଂ ହେଇପାରିଲା ନାହିଁ ଗୋଟେ କଲେକ୍ସନ ଅଫ ଏଭିଡେନ୍ସ ବି ସେମିତି ମାଇ ଲର୍ଡସିପ ପ୍ରୁଫ ବି ହେଇପାରିଲା ନାହିଁ ଗୋଟେ ସିଙ୍ଗଲ ମାଇ ଆଲିଗେସନ ଯେ
Very unusual. So very unusual, sir. I can't tell what is the reasons.
They are very innocent person, my lordship. They never committed such type of allegation. My lordship, যদি আপনি
how আপন जो कहउछन्ते lady, how she is related to this victim?
Mother in law.
ଆଉ ତାଲେ କାଇଁ कहउछନ୍ ତାଲେ? Or you are not a stranger. If your argument is that she is not part of the family, she is a related distant relation of in-laws, which happens.
Yes, ma'am.
That in an omnibus allegation, they name everyone. It has happened at your house or not?
Yes, my lords.
Then?
No single evidence find till today, my lordship.
Sir, don't ask me this question.
Sir, my lordship, jaha document
you ask your clients.
My lordship, jaha document
you ask your clients why there is no evidence. You ask your clients, don't ask the court. Definitely, you see, you are the mother-in-law. It happened in your house.
My lord.
And what is your explanation?
My lordship.
What is your explanation? Because that is admissible in evidence. Something happening at your house.
My lord.
A person dies in your presence. What is your explanation to that? It is a homicidal death?
Yes, ma'am.
It is not suicidal. Suicidal can be explanation. Death has happened or not?
Yes, my lord.
Suicidal or homicidal?
Matter will be tried by under the trial court.
Unnatural or natural?
Unnatural, man.
Unnatural? Then it is homicidal. What is your explanation for homicidal death of a person? Your daughter-in-law who was with you in your house by burning?
My lord.
What is your explanation? What you are saying is very valid to a certain extent. That's at times people are poor, they don't understand. But they may be poor, but they will understand what has happened. At least they will tell you.
Kindly, may consider the accused number 2, my lordship.
Accused number 2 was in her presence. Her daughter-in-law has been burnt.
My lordship, at that time they were not present in that house. My lordship.
Do you mean to say, Mr. Behra, that the women are not to be made accused in 498A?
Yes, my lordship.
Then?
My lordship, after 21 days arrested by her husband, mother-in-law arrested after 21 days of her son arrest. She is not involved, my lord.
Do you realize when she died?
Yes, my lord.
After how many days? How many days she died?
5 days, my lord.
Then how they could have arrested him on the day first when the days he was burned? Obviously, it is a matter of investigation. ଆପଣଙ୍କୁ ଯୋଉଟା unusual ଲାଗେ ସେଟା actually unusual ନୁହଁ. That is very normal. That shows the neutrality of the prosecution.
My lord, kindly allow.
ଜଣକ ଘରେ ଜଣେ ଲୋକ ଯଦି ମରିଯାଉ ତ ସମସ୍ତେ ବାନ୍ଧିକି ନେଇ ଯାଆନ୍ତେ ସେ କାହିଁ 21 ଦିନ ପରେ ନେଲେ?
My lord.
So I can't be that skeptical. ଆପଣ ବି skeptical ହବା କଥା ନୁହଁ. ଆପଣ ଏଗୁଡାକ ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ କୁ ପଚାରନ୍ତୁ.
Consider the lady accused person.
I will consider the lady if she has committed a offense which is punishable by death. She is accused of an offense which is punishable by death. What is the maximum punishment for 302?
Death, my lord.
Then?
My lordship report भी सेमित नहीं, statement भी नहीं, 161 statement भी तांको against my lordship भी किसी भी नहीं.
आपण ताले तो आपण जानछन ताले you know it. Why I asked that? How is it that in a case of a death, unnatural death, homicidal death, there is no statement, nothing.
Similar statement, my lordship, 161 similar statement, my lordship.
Rather, when the accused is poor and victim and the poor and they don't understand, there will be the investigation with promptitude. There will be sufficient material because they cannot influence.
My lord.
So, ଆପଣଙ୍କର କହିବା ଏବଂ consequence are different.
Kindly consider
Mr.
my
Behra,
lordship.
always
Accusing
remember.
two, my lordship. My humble
Mr.
submission.
Behra, always remember.
My lordship.
Statement may lie, but mute facts will never lie. So look at the mute facts.
My lordship.
ଯୋଉଥିରେ କିଛି ବାୟସ ନଥାଏ ଜଣେ କହିଲା ସେ ବହୁତ ଭଲ ଲୋକ ଜନମତ କହୁଛନ୍ତି ଯେ ସେ ଭାରି ଖରାପ ଲୋକ ସେଟାରେ ହେଇପାରେ କିନ୍ତୁ you just look at the facts. A daughter-in-law dies in the place of the in-laws place. She suffers 60% burn injury, not explained. She is treated. Transport to another hospital. She is fit enough to be transported. There she treated. There she dies after, because usually septicemia happens. Is infection, blood infection. And still then the statement is not recorded.
Kindly, my lordship, consider the accused.
No, I have to consider. You have to be kind towards the departed soul who has died also. You can't be that kind that somebody is alive and kicking.
My humble prayer.
And due to unfortunate circumstances, she is inside custody. And the person who has died, you will not be kind towards the soul.
Yes, my lord.
Then?
Only my lordship.
Which is a greater responsibility.
My lordship.
You see, this person is in custody. Apanakar jodi kichi custodial problem achi, then you highlight that. The court will take care of that. Whether she is given proper food or proper shelter or medication, that the court will take care of. The investigation is itself coercive.
Khali my lordship mentioned that during the collection of my lordship, seized the dowry article from the deceased mother-in-law Dulla Bibi, arrested the.
अरे सेटा
एत्ती my lord's value.
सेटा जो सीजर ना सब केस रे हुए that is सेटा तांक सेतरे 302 रे आपनकर कोन हबो डाउरी आर्टिकल आपन से डाउरी आर्टिकल देले भी 302 रे सेटा कोन एविडेंस सेटा
मां को सर मां
302 रे तांकर कोन से करचंती तांको माने the alleged offense, if he has done anything, then say that is irrelevant.
My lordship, last.
Do you think that the court is detaining her because the dowry articles were seized? No.
My lordship, last occasion, London Additional Standing Council stated that he has no objection that if Honorable Court grant bail to the accused number 2, my lordship.
Could be, because I always say that they are neutral and fair, but I have to look at the rejection order and the circumstances. And once I have passed that order asking for the details, I can't recall that order also. In fact, no one can recall.
Only my humble submission, my lordship, only release the accused number 2.
That kindness you have to show to the departed soul also. This person is having any difficulty in the jail. Tell me.
My lordship.
Difficulty, then you tell me, I'll take care of that by passing an order. You have to file that affidavit. How old she is?
My lordship, 52 years.
52. Just imagine 72, 82. They are also inside jail.
They are very sick and
whatever. She's unfortunate, but she has to wait for her turn. Homicidal death of her daughter-in-law is not to be because
already my lordship, he is in custody 7 months, my lordship. Since 1st May.
Let us see their response. There is possibility that nothing will happen.
But lordship, 7 months already rohi sailani.
So seta rahibo hobo seta hobo loko 7 ବର୍ଷ ପରେ ଧରା ପଡୁଛନ୍ତି ତାପରେ ଜେଲ ଯାଉଛନ୍ତି ସେଟା କଣ is that a ground to grant another person a bail? ଆପଣ ତ କହିବେ ତାହେଲେ ଆଜ୍ଞା ସେ 7 ବର୍ଷ ବାହାରେ ରହିଲେ ମତେ କାଇଁ ଆଜ୍ଞା ରଖିଲେ ବର୍ଷେ? In how many cases the period of incarceration is more than the final punishment? ଜାଣିଛନ୍ତି କୋଉ କେସ୍ କହିଲେ? There are several cases. Total period of incarceration during trial is more than the final punishment. Check it. There is clear cases. कौन कह से किछ करी होबन
मां को दे देल मां
देई होबन आज्ञा तांको प्रेजेंस इंसिडेंट हेची शी वाज प्रेजेंट
नथिला
मैं आपन को स्पेसिफिक पचारली
मतलब प्रेजेंस नथिला से रूम रे नथिला मैं
सेटा रूम तांको घरे थिला बेले एटा हेची यू हैव दैट हैव आस्क्ड यू स्पेसिफिकली आ जदी किछ अछि से नथिले अन्य कोठी थिले then you straight away come to that. I can ask them. I can't waste time like for their time also. Every day everyone is saying that the state council is responding. Apan to kiछि nije कहू नांती. Court provide kale apan कहउचंती. By apan कोठी कहले that so and so was not present. I'll ask for them that it is part of the case diary. जणे कहले जे case diary तो 161 statement दा किछि value नै काई करा होछु 161 statement. Case diary is a reflection of the contemporaneous investigation. कौन एविडेंस के देथिबे जे से नसी सेठी रहंतिनी एटा ही पारे आपनकर 498 केस रे जे नथांदी तांकर भी से माने कहि दियंती ताना स्टेटमेंट दे दियंती तो सेटा आपण स्टेट अवे कहंतु ना नथिले बोली but you have to be serious in your contention, mister. If it is found to be false, then the petitioner will be in trouble. You see, I mean, you can't take a the death of a upon ji mori gale tankar boyas kete hitla
22 years.
22-year girl dies and 52-year you just imagine 52-year of lady, she is staying in jail, you are concerned, but a girl dies after being burnt half. She would have struggled for her life for 5-10 days in the hospital.
My lord, say before
excruciating pain. You can't imagine. You can't imagine if somebody suffers a burn, what kind of pains he or she suffers. Unimaginable.
My lord, say ସେମାନେ ତାଙ୍କ ବାପ ଘରେ ରହୁଥିଲେ my lord, say ଝିଅ ଜ୍ୱାଇଁ ବି ତାଙ୍କ ବାପ ଘରେ ରହୁଥିଲେ କାମ ଦାମ ସେମାନେ କରୁଥିଲେ କଣ ଗୋଟେ ଇନସିଡେଣ୍ଟ ହେଇଛି ଯୋଉଥିରେ କି ଝିଅ ନିଜ ଦେହରେ my lord say କିରୋସିନ ଲଗାଏ.
Now, yes, now you have told the truth. There you have to come clean. You have to tell clearly that what has happened.
My lord.
That you have to.
In
yes.
fact, that incident is not forthcoming anywhere. Why she set herself on fire is not anywhere.
କାହିଁକି ହେଲା କିଏ ହେଲା କୋଉଠୁ ସେ ଆଣିଲା ସେ ଇଏ everything you have to come out. ସେମାନେ ଆପଣ ସେଇଥି ପାଇଁ ରଖିଛନ୍ତି.
His statement doesn't reflect. No 161 statement gives a motive for her to set herself.
Something has happened, sir. It is not just that ମାନେ ଗୋଟେ ଗତାନୁଗତିକ ଭାବରେ କିଛି ଗୋଟେ ହେଇଗଲା ଯୋଉଟା ଲୋକଟା ପୋଡି ହେଇଗଲା ଏବଂ ତାକୁ ହସ୍ପିଟାଲ ନିଆଗଲା ଏବଂ ରହିଲା. You are the only person there. ପୁଅ ସେତେବେଳେ ଜ୍ୱାଇଁ ଘରେ ତାର ସେ ହଜବେଣ୍ଡ ଘରେ ଥିଲା ସେତେବେଳେ.
My lord,
ସିଏ ବି ଘରେ ଥିଲା.
ପ୍ରେଜେଣ୍ଟ ଥିଲା my lord, ସେ ଝିଅ ଭିତର ପଟରୁ କବାଟ ଦେଇକି
ସେଟା କିଏ କହିଲା ସେଟା କୋଉଠି ସେଟା ଅଛି?
My lord, from the source.
ଆପଣ don't go by, always look for the mute circumstances. Don't go by any kind of speech. I was, sir, lady perpetrating committing a crime doesn't, where is the distinction? ସେଟା ବି କେତେ ଥର ପଚାରିବି, a lady who has committed alleged of committing a crime is to be treated differently as far as bail is concerned. It is a consideration for the gender. But for heinous crimes, if a heinous crime, equally heinous crime, the same crime is committed by gents, the criteria will be different criteria will be applied to a lady.
My lord, there is no specific statement against of lady.
Who will state that? Where is the eyewitness?
Witness.
ଆପଣ ସେଟା କହୁନାହାନ୍ତି କାହିଁକି?
Witness ନାହିଁ my lord, 161 ବି ନାହିଁ.
161 ସେଟା କୋଉଠୁ ଆସିବ? କିଏ ଦବ?
My lord,
ଭଗବାନ ଦେବେ? ଏଟା ତ ଭଗବାନ ନୁହଁ, ଆଲ୍ଲାହ ଦେବେ.
जो विटनेस माने my lords भी ଦେଇଛନ୍ତି ତାଙ୍କର ସେମିତି କିଛି statement ସେ allegation.
ଆରେ ଆପଣ circumstances ବୁଝି ପାରୁନାହାନ୍ତି. You are not getting the point I am driving at you. In that circumstances, who are the relevant witnesses? Those have been examined. Straight away କହିବେ ସେ ଆଜ୍ଞା ଯାଉଥିଲେ ରାସ୍ତାରେ ସେ ତାଙ୍କ ସାମ୍ନା ଘର ଲୋକ ସାମ୍ନା ଘର ଲୋକ ଥିଲା ଇଏ ଦେଖିଛି ଏହା କହିଲା. ଆପଣ ଯୋଉ କହୁଛନ୍ତି ଯେ କେହି ଦେଲେନି ସେଟା ତାର କିଛି ମାନେ ନଥାଏ. ଆପଣ ଶୁଣିଥିବେ ମିଷ୍ଟର ଦାସ କହୁଥିଲେ conspiracies hatched in darkness. ତେଣୁ ଯୋଉଟା ସବୁଗୁଡାକ ବିହାଇଣ୍ଡ ଦ ବ୍ୟାକ୍ କରାହଉଛି ତ କଣ କିଛି ଡିଟେକ୍ସନ ହେଇପାରିବନି? Then without anything also the case has been proved and conviction has been upheld because circumstantial evidence. So stage ଆସିନି ଏ ପର୍ଯ୍ୟନ୍ତ. But କେବେ instruction ଆଣନ୍ତୁ? How much time for the time?
My lord, about 10 days.
Mr. N. Behra for the petitioner, Mr. Devasis Naik AGF for the state, the learned counsel for the petitioner submits that the petition OP number 2 is in custody since 1/5/2023.
My lords.
And C being a lady. Whole problem, Mr. Behra, actually you don't understand. Once I start writing in these lines, then I have to observe that 302 suspicious circumstances, she was present.
My lord.
Alibi kichi nahi. If I start writing that, then what is the possibility of granting you bail?
My lord.
कौन लिख ले? Should be shown indulgence for prayer of bail, for grant of bail. On being specifically asked that whether any material is when material is there to not to array the opinion of petition number 2 as a co-accused, accused oblique co-accused in the incident, the learned AGA submits that her presence at the when the occurrence happened is not disputed, and the daughter-in-law of the OP number 2 the petition number 2 died at the house of the petition number 2 after being burnt, after suffering burn injuries कर दिया तो burn till the direct after suffering burn injuries which are yet to be explained, which is being investigated. Para. The learned AG is also directed. Sub para kar likhundu, but next para kar diyantu. Learned AG directed to obtain instruction in terms of the order dated 22/11/2023. At paragraph 2, the following directions were issued. Paragraph 2 ta quote kar diyantu. Apan par order ta achi? That 22/11 order?
No, my lord.
The upload kar diyantu.
I have the order. I mean, it's written in hand.
Yes. No, I have, because it is very clear. Copy of the order dated 22/11/23 and order date today's order shall be handed over to the learned AG. Yes, next.
37.
My lord has posted this matter.
List on date dakini. I'm sorry, date dakini. Date 15 18 kebe rakhibe 18 12 you seek for 10 days time. Okay. 18 12 20 23.
38.
37 38. Yes, 38.
Last occasion, your lordship has.
You are Mr. Swai?
No, Mr. Gauri Kumar Rath.
Upon the Gauri Kumar Rath nuhanti?
Again.
Upon be acha. I'm sorry. See Gauri Mohan. Acha.
Yes.
Mr. G.K. Ratha for the petitioner. Mr. Devasis Naik AGA for the state. Upon affidavit file kale?
No, my lord.
The Lord Counsel for the petitioner seeks accommodation to file affidavit in terms of the order dated 11/9/2023, reiterated on reiterated on 10/10/2023, indicating the past allegations of criminal activity, if any, against the petitioner. The learned AGA shall also obtain up-to-date instructions regarding the public case diary and also instruction regarding health condition of the injured Abhishek Malik. Aschi eta Mr. Naik?
No, my lord.
Asini?
Condition I haven't received.
केबे affidavit देबे आपण तो affidavit देबेनी से केबे सॉल्व करियो से instruction केबे नेबे?
No, my lord. Actually, that is not the mother of the petitioner is unable to come. She will file the affidavit.
Where is the direction that mother of the petitioner will file affidavit?
No, the petitioner may not file. Other family members are not in the
family. अन्य मनस्क रहिबे.
Yes, my lord.
मु बिल्कुल mother, father, petitioner किछि डाकिन.
नहीं.
कौन डाल डाकिछि कोन?
The proclivity affidavit shall be filed on behalf of the petitioner.
बढ़िया मन रखछन ताले. अब mother को आनले ता भितरे. आपण ये फाइल करिवे, that is not an issue. आपण काहे मदर को भितर आउचंदी कहले? Anyone on behalf of the petitioner, but not the of course not the counsel.
Yes.
Now I am seeing advocates have started filing affidavit.
No.
आपण जदि affidavit दोनांती, how you will get instruction? आपण तो अर्जन करी चालिले. You see, that order was passed by brother Justice Narsingh.
Family member are there. That's why.
अब crime काहे करचंदी ताले? जहांकर केही नाहंती दुनिया रे से क्राइम करिकी जेल रे रहबे मदर को डाकी एफिडेविट करिया पे
Mother Nadala, no
बुझिपाउन आपण
other person.
you have to be philosophical also when you are a criminal lawyer you have to be philosophical.
Yes.
11/9 re Justice Nursing passed the order.
Yes.
Today on 1st of December I have to repeat that.
No, my lord, I have already passed the information and
that's not important. You are just simply adjourning the matters and ultimately जो दिन आपण फाइल करिए सेदिन को टेक अप हो बोली. That I was highlighting. ଆପଣ ନ ଦେବେ that's your କିଏ ଦେବେ ମଦର ଦେବେ ଫାଦର ଦେବେ କଣ ସେଥିରେ ଅଛି ଆପଣ ଫାଦର ଲେଟ୍ ବୋଲି ଲେଖିଛନ୍ତି ଏଥିରେ
ନା
ଆଉ କେମିତି କହୁଛନ୍ତି କେହି ନାହାନ୍ତି ବୋଲି ଆଜ୍ଞା
ଫାଦର ଆସିପାରିବେନି ଓଲ୍ଡ ଏଜ୍
ଆପଣ ଏବେ କହିଲେ କେହି ନାହାନ୍ତି ଫ୍ୟାମିଲିରେ ଖାଲି ମଦର ଆଣ୍ଡ ସନ୍ ଆପଣ ତ ଫାଦର ଲେଟ୍ ଲେଖିବା କଥା
ନା ଫାଦର ଆଲାଇଭ୍
ଠିକ ଅଛି କିଛି ସମୟ ବନ୍ଦ କରିଦିଅନ୍ତୁ Yes, next. केबे affidavit देबे as prayed for affidavit be filed by date कहंतु आगे जल्दी करंतु 15 तारिख सुधा देबे
no thereafter my lord
अरे affidavit ता 15 तारिख सुधा दियंतु ता कॉपी दियंतु ता पर डेट गोटे नियंतु
आगे
affidavit be filed by 18/12/2023 copy be served on the learned AGA for the state to obtain instruction January date कर दियंतु list no List on 9 January. Now further time.
No.
9/1/2024. अरे further time no ना 9/1 no कहले बुझ पाली
9th
ठीक अछि तो
yes
ठीक अछि yes next
39
साहू एरा कोन से जो इंटरिम टा की
yes lordship
सेटा एक तो सेम ऑर्डर कर देबे से कॉपीटा दे दियंतु You should not have done this. You should have, you missed it actually. ଆପଣ ଏଟା କେମିତି ଗଲେ କେଜାଣି ସେ ଅର୍ଡରଟା ଦେଇ
May I prefer urgent certificate today?
ହେଇଯିବ ଏଇଟା ଯାହା ଅଛି ସେ ଅର୍ଡର ହବ ଏଇଟା ଯୋଉ ଦିନଠୁ ଯିବେ ସେଇ ଦିନଠୁ ତ ହେଇଥିବ ଆଉ କଣ ତେଣୁ ଡେଟ୍ କିଛି ପଡିବାର ନାହିଁ This is that matter where interim bail was granted Mr. Standing Counsel obtained instruction but he did not mention this matter
yes
so it was left out
there 4 cases are there this left out
IA 1547
yes lord
IA 1547 of 2023 PLAPL टा जहां नंबर अछि ए ऑर्डर टा कर देबे सर्टिफाइड कॉपी ड्यूरिंग कोर्स ऑफ द डेट कर देबे छाड़ दियो हैला बिकॉज़ ऑलरेडी द ऑर्डर हैज बीन केते दिन हेलान से ऑर्डर टा
23/11
तो रिटर्न इट इज ओवर नाउ 23 आज 1/12 हे गेलान यस नेक्स्ट प्लीज 40 आज्ञा डेट टा आपण से अछि दे सॉरी
कोन
3 जनवरी नियंत्रण देखि दियो से 3/1 Mr. Sahoo list on 3/1 3/1 आपण एटा कहि थांते ना yes
5 weeks should have granted for 5 weeks
5 weeks because actually now it is frustrated
yes
yes
40
I'm
yes
looking for the informant my lord
yes you are Mr. BM Bhuya आपण informant
okay wait please lord I'm appearing on behalf of Mr. Kedar Sahoo my lord
this is item 40
item
your name sir
my lord Sanket Kanungo
Mr. S. Kanungo on behalf of Kedar Shankar Sahoo Mr. K. S. Sahoo for the petitioner Mr. Devasis Naik AGA for the state you are Mr.
Siddharth Gautam Das on behalf of Mr. Samant.
Mr. S. G. Das on behalf of R.R. Sahoo
Yes ma'am.
R.R. Sahoo R.R. Sahoo affidavit copy टा आपण केबे फाइल कले केबे देले 23 नवंबर you have received copy Mr. Naik
my lord
this matter was earlier there similar matter or if I roughly remember now some other petitioner was there you were appearing and some informant was there
No, my lord. This is another case.
Here the highest punishment is
My lord, we have
307.
life under section 471.
Life imprisonment. Yes, what do you say, Mr. Siddharth Gautam?
My lords, out of the trial is going to end, my lords. Out of 7, PW 6 has been examined, my lords. And my lords, he is having antecedents, my lords.
2 antecedents are there.
Yes, my lord.
You see, in 16 antecedents, yesterday I was shown an order, the court has granted. Don't, may not be. ଆପଣ injured କିଏ ଥିଲେ କି? Are you appearing for any injured? ହେଇଥିଲେ? Cheating?
Yes, my lord. Cheating.
ଆପଣଠୁ ପଇସା କେତେ ନେଇଛନ୍ତି? କଣ ନେଇଛନ୍ତି?
4 lakhs, my lord.
ଆପଣ deposit ପାଇଁ instruction କଣ ନେଇଛନ୍ତି?
My lord, we have not received the money directly from the informant. And in the charge sheet also, there is no specific mentioning with respect to us receiving any amount.
You are a kind of a conduit.
My lord, we were the mediator in this case.
He impersonated me, my lords.
And
Mr. Siddhartha, sorry, Mr. I'm sorry, appearance upon लिख लेता. The learned counsel for the petitioner submits that the petitioner is in custody since.
My lord, since 24/7/2023.
24/7/2023. The final prosecution report has been already submitted on
18/9/2023.
18/9/2023. The trial has progressed. It is submitted that. Then para lekhantu, the learned counsel for the learned AGA for the state, referring to the materials contained in the case there, he opposes the prayer for bail. However, it is not disputed at the bar that the final prosecution report has been submitted and the trial has progressed substantially. However, Purburu, insert of anchor submission. The learned counsel for the informant insert karti huntu. The learned counsel for the informant vehemently opposes the prayer for bail, submitting that the informant, being a poor person, has been deprived of his savings due to the act of the petitioner and opposes the prayer for bail. Opposes to dithar bodhe gala. Vehemently opposes thar likhile torta next full stop kar debe. Para having heard the learned counsel for the apon kete tanga deposit karibe. Upon to smaller amount re jane 1.5 lakh tanga deposit karchanti. Though I understand the argument is that this is not recovery proceeding. The informant will not get anything. Upon to kichi paibeni kon labha biche. Borom kichi goodwill rakhantu se jodi apan debe. Yes, I'm just inviting some the ideas from you. Younger people should be having more ideas. The having heard the learned counsel for the petitioner, the learned AGA for the state, the learned counsel for the informant, the court is inclined to grant bail to the petitioner subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter, which shall also contain a condition that any violation of deviation from any of the terms and conditions that would be imposed shall result in filing a petition for cancellation of bail by the investigating agency, /informant, /victim. Yes. Disposed of accordingly. The petition stands disposed of accordingly.
Deeply obliged.
Yes, please. Petitioner non hybrid mode lekhibe. Mr. Devasis Naik, AGA for the state. Non appeals for the petitioner when the matter is called to grant further opportunity, list on 18/12 ତ 18/12/2023
42.
In this matter, my lord, this similar my lord matter is pending. Lordship my lord fixed the date 6th of December. Let it come, my lord, 6th of December.
This is from Bihar.
Similar matter is pending. Go take a second. In fact, I have not completed the last matter. I'm just looking at the last order.
Three similar matters.
Just wait. Last matter deposition copy apan ko dele se.
In deposition, those are actually 164 statements that he had uploaded.
Affidavit, my lord, already filed.
164 statement recorded by JMFC Berhampur.
No, my lord.
नहीं पुराना मैटर कथा कहउछन
से अपन से मुझसे सुनु नांती मु कहल कि अपेक्षा करंतु से सुनु
पुराना
ना
मैटर का
Yes.
पूर्व मैटर का
ठीक अछि डेट 18/12 तो हैला 18/12
मेल
यस ने हां 42 Mr. S.K. Patnaik for the petitioner, Mr. Devashish Naik AGA for the state. जोड़ा पेंडिंग अछि एटा अन्य बेंच रे अछि कि
ना एट पेपर लॉर्डशिप my lord 6 December. Lordship fixed the date 6 December.
It is submitted by Mr. Patnaik, the learned counsel for the petitioner, that the connected matters have been posted to 6/12.
Again.
List on 6/12. Yes, next.
43.
Would you receive, may I read your lordship?
Yes.
This is the case under section.
But registry comply kale order ta. But last time comply kariya pai.
My lord, I have sent the copy, my lord.
Then where is the report? I have to check for the report.
Yes, my lord.
Can you hear me?
Yes, my lord.
On 16, there is an order that you will file the copy in the registry.
Yes, my lord.
When did you file that copy? My record shows it is not filed. Date ko dina filed.
My lord, I filed on the day. I filed on the day, my lord.
Filed on the day माने आपण फाइल कले बुझन टाइम नै थिले 6-10 रे कलेनी 13-11 रे करथिबे.
Yes, my lord. Advocate
पुरी रे फाइल कले ना कटक रे
सर पुरी रे सर
के अछंती सेठी आपनकर ऑफिस कोर्ट रूम रे एसो को कहबे
सर.
Yes, who is there in present in the virtual courtroom from the registry? Please come before the camera. Yes, he says that he has filed a copy in the registry. Can you verify?
Sir,
Again?
Sir,
हाँ से कॉपी टा आपण फॉरवर्ड करिवे टू द लॉर्ड ट्रायल कोर्ट जो कोर्ट रे केस टा पेंडिंग अछि सी सेटा तांको ऑफिस रु फॉरवर्ड करिवे इन्फॉर्मेंट को पाखु.
my lord, may I speak? My lord, on the day, the other staff, Niranjan Samantara, has sent, but he has not sent to the trial court. He has sent to the Advocate General, my lord.
Advocate General तो स्वयं एठी अछंती.
Okay, sir. Let it be common any other day.
ताका पाखरे आपण कहउचंदी सुनंतु तांकर कॉपीटा से आगु रखि स्कैन करके रखिचंदी ऑर्डर हैला पर ठेई देबे.
Yes, my lord.
But trial court कोड कॉपीटा आनिबे ट्रायल कोर्ट रे
tomorrow we will comply. Tomorrow we must comply, my lord. Tomorrow we will set that.
नहीं तापरे रिमोट जा लोकेशन रे कोर्ट हेले डिफिकल्टी हबो ही हबो. आपण जदी थी पाए को पूरी रे आपण तो पूरी पळेले कटक रे रहिलेनी
सर देह खराब होला सर
केते वर्ष परे पूरी पले भारी
20 ବର୍ଷ ଗଲା ପରେ ଲାଗେ ସାର୍ 20 ବର୍ଷ ସାର୍
20 ବର୍ଷ କେମିତି ଆପଣ ତ 90 ମସିହା ବେଳକୁ କଟକରେ ଥିଲେ ବେଶୀ ଏବେ ତ ଆପଣ 20 ବର୍ଷ ପ୍ରାକ୍ଟିସ ପରେ ପଳେଇଲେ କହୁଛନ୍ତି
ଆଜ୍ଞା ସାର୍ 20 ବର୍ଷ ପ୍ରାକ୍ଟିସ tomorrow we will comply let it come
ସେ ବର୍ତ୍ତମାନ ମିଷ୍ଟର ରାୟ ହାଜ understood it ଆପଣ ସେଟା ମାନେ ଫରୱାର୍ଡ କରିବେ ଯୋଉ ଟ୍ରାଏଲ
yes ma'am
the learned counsel for the petitioner लिखले Mr. being present at the virtual court Odisha High Court at Puri addresses arguments. It is submitted by the learned counsel for the petitioner that though the copy was filed in the registry of the registry in the office of the registry at Puri, but the same has not been forwarded to the learned session judge public court in session of the matter for transmitting the same to the informant public victim through its office. It is submitted that a further and another copy will be served during course of the day within 2 days, within 2 working days in the office of the registry at Puri. The copy shall be forwarded to the learned court in session of the matter to forward the same to the informant public victim and also intimate that they have a right of audience in the present proceeding pending before this court. The learned counsel for the informant public victim can appear at the virtual court of High Court, virtual court, Odisha High Court at Puri. Yes. କେବେ ଆପଣ ଦେଲେ ତାହେଲେ କଣ ଭେକେସନ ପରେ ଆସିବ
ଆଜ ମାଇ ଡୋଣ୍ଟ ୱିଶ
ଆରେ ମୋର ଆପଣ ତ କପି ଦେଲେନି କିଛି କଲେନି ମୁଁ କଣ ୱିଶ କରିବି 6-10 ରୁ
କପି ଦେଇଛି ସାର୍ ମୋର ରଙ୍ଗ
2 ମାସ ହେଇଗଲା ଆପଣଙ୍କର କେସ୍ ଖାଲି କପି ସର୍ଭିସ ରେ 2 ମାସ ପଳେଇଲା लिस्ट ऑन लेट अस टेक ए चांस ऑन 18th वीक रे गोटे डेट कोटा कोंतु गोटे 19 19/12/2023
34
yes Mr. Satyaranjan Mulia for the petitioner Mr. ତାକୁ ବୁଝିବାଟା କଷ୍ଟ ଇଏ କଣ ଆଫିଡେଭିଟ ଅଲଗା ଆପଣ ଅର୍ଡରଟା କେମିତି ଡିକ୍ଟେଟ ହବ କହିଲେ ଅର୍ଡରଟା ତ ଫେର ଲେଖିବାକୁ ପଡିବ ଯେ ନାଇଁ ଅମକ ଲୋକର ଏ ଆଫିଡେଭିଟ ସମକ ଲୋକର ସେ ଆଫିଡେଭିଟ ଦ୍ୟାଟ୍ ଇଜ ମିଷ୍ଟର I mean honorable justice Mr. Honorable Justice BP Das used to throw file when you file about 100 persons service matter because you can never complete a order anyway that's in a lighter vein.
In respect to my lord, petition number 1 my lord.
ଆପଣଙ୍କର କାହା ଅଗେନ୍ଷ୍ଟ ସବୁଠୁ ବେଶୀ ଅପୋଜ କରୁଛନ୍ତି କାହାକୁ ବେଶୀ ଆଜ୍ଞା
yes of 3
ଆପଣଙ୍କର ମ୍ୟୁଟେଡ ରେସ୍ପନ୍ସ ତ ୟୁଜୁଆଲି ହୁଏନି ବଟ୍ ଦୋ સોબર ବଟ୍ ନଟ୍ ମ୍ୟୁଟେଡ ଆପଣଙ୍କର ଏକ୍ସେପ୍ଟ ଇନ୍ ରେସ୍ପେକ୍ଟ ଅଫ 3 ଆପଣ ସବୁଠୁ ଷ୍ଟ୍ରଙ୍ଗ ଅବଜେକ୍ସନ
ଫର୍ମାଲ ଅବଜେକ୍ସନ
ଆଜ୍ଞା
I am fairly I am submitting now ସେ କଷ୍ଟେଡ ରହିଗଲେଣି ମୁଁ ସେପଟ ସାଇଡରେ ବେଲ କରୁଛି having my submission
ଉଭୟ ପକ୍ଷରେ ଆପଣ ଏଟା ଫାଇଟିଂ
ନାଇଁ
ଆପଣ ବି କିଛି ଲୋକ ପଳେଇଥିଲେ କି ଭିତରକୁ
ସେମିତି ନାହିଁ ଯେ
ସିଏ କହୁଛନ୍ତି ଏଇଟା ଗୋଟେ ଲାଇଟର ଭେନରେ ସେ ଅପୋଜ କରୁଛନ୍ତି
ସେଇଟା ତ ବୁଝିଲି ସେ ପ୍ରଥମେ କହିଲେ ଥାର୍ଡ so then I realized that I have asked the ମାନେ correct question ଟା ମୋ question ଠିକ ବୋଲି ମୁଁ satisfied ହେଇଗଲି ଠିକ question ତାହେଲେ 1 2 ତ ତାହେଲେ 1 2 ତ ସେ ଦେଇ ଦେଇଛନ୍ତି ଆପଣଙ୍କର ଭେରିଏନ୍ସ ଅଛି କି କିଛି ତାଙ୍କର ଆଫିଡେଭିଟ ଆଉ ଆପଣଙ୍କ ପୋଲିସ ରିପୋର୍ଟ नो ଭେରିଏନ୍ସ ତାହେଲେ ଲେଖନ୍ତୁ ଆପଣ ଆମେ ଗୋଟେ ଏମିତି କରୁଛୁ ଯେ what we are doing the prayer for bail for petition number 1 ତାପରେ ଲେଖା ହେଲା petition number 2 ତାପରେ 3
ଜଣ ଅଛନ୍ତି
କାରଣ ମିଷ୍ଟର ସାହୁଙ୍କର ଷ୍ଟାଇଲ ଯାହା ସେ ଆଗ 1 ରେ ଫାଇଲ କଲେ 2 ଟା ଆର୍ଗ୍ୟୁ କଲେ ଆର୍ଗ୍ୟୁମେଣ୍ଟ ସରିଗଲା ପରେ you or Mr. Standing Counsel stood up, said that there is no affidavit filed. So then he said, oh yes, I have not filed affidavit. Jyotirmoy Sahu. So I will take time to file affidavit. So order bhi jada ki thi se gala se order gala. So after rejection of one, in view of the submission made by the learned counsel for the petitioner, so affidavit be filed. The Mr. Satyaranjan Mulia for the petitioner, appearance egala. The prayer for bail of the petitioner number 1. It is submitted by the learned counsel for the petitioner that the petitioner is in custody. Apanakar samastar custody date ekka. The petitioners are in gote order the petitioners are in custody since
4/8/2023.
4/8/2023. In the meanwhile, the final prosecution report has been submitted on
9.
Mr. Kanungo, again, final charge sheet has been submitted.
Charge sheet, my lord.
I have no idea.
Final for my lord. Exact date.
Final prosecution report has been submitted on
2/10/2023.
2/10/2023. Trial progress karchi?
No.
Considering the period of incarceration, the petitioners be shown indulgence as far as prayer for bail is concerned. It is further submitted that the petitioners are local residents and they shall subject themselves to the jurisdiction of the learned court in session of the matter and shall also abide by all terms and conditions that would be imposed if prayer for bail is allowed. The learned AGA referring to the past allegations, the learned AGA referring to the materials contained in the case diary and the past allegations against the petitioner opposes the prayer for bail. The learned counsel appearing for the informants or plural singular? Informants. For the informants. Informant oblique victims vehemently opposes the prayer for bail referring to the past allegations of criminal activity. Para. However, it is not disputed at the bar that in the meanwhile, the final prosecution report has been submitted. Para. Having heard learned counsel for the petitioner, the learned AGA for the state and the learned counsel for the informant oblique victim, the court is inclined to grant bail to the petitioner subject to such petitioners subject to such stringent terms and conditions that would be imposed by the learned court in session of the matter, which shall also include a condition that any violation of oblique deviation from any of the terms and conditions that would be imposed for grant of bail shall result in filing of petition for cancellation of bail by the investigating agency oblique informant oblique victim, disposed of accordingly.
45.
No one is there. Petitioner none, opposite party blank. The learned counsel for the none appears for the petitioner when the matter is called, nor any instructions has been nor instruction achi. The office note dated 30/11/2023 indicates that The receipt showing service of receipt showing payment of rupees 150 to the opposite parties has not yet been filed. Opposite party भी non लिखी दियो. To grant further opportunity to the petitioner, list on उनतीस एक को 2024 29 एक 2024. Yes, next.
46. I am for the respondent.
Mr. Lenka.
My lord. Prabhat Lenka.
Mr. AGA, Mr. S.S. Kanungo AGA for the state. Mr. You are appearing for, sir, opposite party?
Opposite party.
All. For the opposite parties. Mr. M.R. Lenka for all the opposite parties. Upon instruction no apin thila kon jana padla, sir?
Na kichi jana padla. Chithi pathai delu je kichi reply ase.
The learned counsel for the opposite party submits that despite his efforts, he has not been able by sending letter through registered post with AD. He is yet to receive any instructions and may be accommodated further as prayed for. Kebe after vacation. List on 31/1/2024. Yes.
23 years. 47.
Mr. Manish Dheer on behalf of S. Nayak for the petitioner. Opposite party blank. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instruction and also comply with the office notes put up by the registry. Oblique SR. SR oblique office note for them. Comply with the stamp report as well as office notes. List on 16/1/24 as prayed for. Yes, next. 48. None appears for the petitioner when the matter is called to grant further opportunity. List on 18/1/2024. The defects as pointed by the SR be complied be removed in the meantime.
49.
Miss S. Jenna, Sangeeta Jenna on behalf of Sujata Jenna, M.S.S. Jenna on behalf of S. Jenna for the petitioner. Mr. Opposite party blank, the learned counsel for the petitioner seeks accommodation to obtain up-to-date instruction and remove the defects pointed by the SR. As prayed for, list on 18/1/24.
50.
Same order. S. Jenna on behalf of S. Jenna. Same order. Yes, next.
51.
None for the petitioner when the matter is called to grant further opportunity. List on 31/1/2024. Defect as pointed by the SR we removed in the meantime.
52.
Same as 51.
53.
Mr. Raut was there. None appears for the petitioner when the matter is called to grant further opportunity. List on 25/1/2024.
54.
Postal requisite file है नहीं?
My lord,
54 Mr. S.S. Kanungo AGA for the state. There office note लिखा है नहीं? ये कौन करता था? पूरे के बनने दे चीज़ 10 को 15 The learned AGA submits that due to inadvertence, the notice on admission the requisites for issuance of notice and admission to the opposite party could not be filed. The office note indicates that complete requisites were not filed. Sub paragraph the office note indicates that. The learned AGA seeks for further time. Prayer is allowed. The late requisites for issuance of notice on admission, as directed earlier, shall be issued by registered post with AD in present correct address. Requisites filed within 3 weeks. Requisites be filed within 3 weeks. Yes, next.
Okay. 55.
Mr. Das is not there. Mr. Sangram Das for the petitioner, state. Opposite party blank. The learned counsel for the petitioner seeks accommodation to advance arguments. Miscase order karibe. Miscase 24 of 2013. List on next week. Eta order search. Eta ebe hei paribo. चौदह तेरह से वीक रही परियो 15/1/2024 ए 15/12/2023. Yes, next.
56.
55, Mr. Sangram Das, standing counsel for the state, opposite party blank. The learned counsel for the petitioner seeks accommodation to advance arguments as prayed for. List on 8/1/2023. Sorry, 15/12/2023.
56.
Mr. Rabindra Kumar Sahu, petitioner none. None appears for the petitioner when the matter is called. To grant further opportunity. List on 19th January 2024. Defects as pointed by the SR be removed in the meantime.
57.
Same as 56. Or date kebe? 57. Same date. Okay.
58.
Next week.
Your name, sir?
Mr.
Mr. R.K. Sodangi for the petitioner. Opposite party blank. The learned counsel for the petitioner seeks accommodation to remove the defects as pointed by the SR. As prayed for further 2 weeks time granted to remove the defects. Remove the defects and SR be made. And further SR be made.
59.
Yes.
Lordship, item 59.
Yes.
I seek for an adjournment, Lordship.
Your name, sir?
Abhijit Mohanty.
Abhijit Mund.
Mohanty.
Mr. Abhijit Mohanty on behalf of Rajit Roy.
Yes, Your Lordship.
Rajit Roy. Abhijit Mohanty on behalf of Rajit Roy for the petitioner. Opposite party blank. The copy has not been served. There is a noting.
Your Lordship, I'll take
The
instruction.
learned counsel for the petitioner shall seek accommodation to obtain instruction and also to serve copy on the learned counsel for the learned counsel appearing for the opposite party as directed earlier. As prayed for list.
By
About 22nd January 2024. Yes, next.
60.
60, my lord.
Copy note, sir.
Short, my lord.
Sir Vijay.
Yes, my lord. Original receipt of Mr. SKJC counsel file, opinion filed, my lord.
Mr. Standing counsel for the state, opposite party none. The learned counsel for the state, learned standing counsel submits that the copy of the brief case brief has been served on the learned counsel appearing for the opposite party, Mr. Joshi. The receipt shall be receipt original ta achi rahi jaichi apan pakhare.
Original receipt, my lord, are filed on 22/3, my lord.
The receipt of the receipt memo shall be filed in the registry.
I got the Xerox.
Receipt memo oblique photocopy. ଆପଣ ଆଉ ଥରେ file କରିଦିଅନ୍ତୁ.
I will file this.
The registry, the noting that the copy not served shall be treated to be complied with.
But regarding service of copy, my lord, copy not served.
Oh,
Is a receipt regarding, my lord, payment of cost.
Achha. The learned counsel cutting lekhodu. The learned standing counsel submits that he shall serve copy of the petition within 7 days, 7 working days on the learned counsel who has entered appearance for the opposite party. Prayer is allowed. Let copy be served. Receipt be filed in the registry. Yes. Yes. Next.
61. So I am for the appellant on behalf of Mr. Das. I pray for adjournment.
Mr. Sheikh Aziz, you are Mr. Aziz?
My lord.
Mr. Sheikh Aziz for N.K. Das, on behalf of N.K. Das for the petitioner, opposite party blank, the learned counsel for the petitioner seeks accommodation. As prayed for, list on 19th January, or you want further time?
No, my lord. It's okay.
19th January 2024. Yes, next.
62.
Petitioner none, opposite party blank. None appears for the petitioner when the matter is called. To grant further opportunity, list on 12/1/2024. Yes, next.
63.
Same order as 62.
63, my lord.
63 as a state is a party. Sorry,
Yeah,
63 Mr. Standing Counsel for the state.
Yes, my lord.
Opposite party blank.
Only, my lord, delay condone. That is for
Admission notice nahi chanti.
admission notice not gone, my lord. Only delay condone since non-appearance last order 1/3/16 order, your lords may see. Non-appearance.
Hard learned counsel for the learned standing counsel for the state. Issue notice on admission.
My lord, may I kindly see the order dated? My lord is
Requisites for issuance of notice by registered. Yes, it was listed, directed to be listed for admission. So
My
notice
lord-
was not issued.
my lord, one thing, my lord. 11/2/2015 order. I think,
No, 1/3/16.
my lord's signature,
I was appearing as a counsel.
I think it is
Yes.
2015, my lord was ASC.
15 re bodhe.
I think,
Yes.
no. No. My lord, 2015, my lord was.
ସେ କହିଥିବେ କି ମୁଁ ଯୋଉ ମାନେ ଅଭ୍ୟାସଟା ଯାଇନଥିବ ଏସି ଲେଖୁଥିବି ଆଉ
This signature, I think it is not.
କୋଉ କୋର୍ଟ କହୁନାହାନ୍ତି ଜଷ୍ଟିସ ସାହୁ
Justice Pujari.
ପୂଜାହାରୀଙ୍କ କୋର୍ଟ
Oh, 2015 तो ठीक 2015 April 23rd में तो
April, नहीं 5 रे माने 5 रे my lord was regime. 5 रे तो 4 रे हला notification टा.
अरे ମୁଁ ଯେତେବେଳେ resign କଲି ମୋର ମନେ ଅଛି
ନାଇଁ
23rd of April 2015
So I was assigned when the Justice Pujari was in DB. So whenever there was any single bench, I would have appeared.
That is
Otherwise, I
not
have
a signature.
no.
My
That's
lord's signature is something like that.
who signature
had the land standing counsel issue notice on for the state. The petition has been filed seeking leave to appeal.
By registry
against yes, against the judgment dated 17/9/2009 passed by so and so in so and so लिखिदेबे in case number लिखिदेबे judge को ना लिखिले तापर case number लिखिले acquitting the petitioners who are facing trial under section 448 देखिए लिखिए para 17 ने 354 376 read with section 511 of IPC acquitting the opposite parties ने petitioners डाक देली की नहीं भूल है सब बेले मैं भूल डाकुची the acquitting the opposite parties under section 235(1) of CRPC ला who were facing trial under section so and so yes तापर लिखिबे hard learned standing counsel for the state issue notice on admission then para requisites for issuance of notice be filed এটা ଆପଣଙ୍କର ଜଣକୁ କରିଛନ୍ତି କାହିଁକି
One accused may be.
ଉମାକାନ୍ତ ଦେହୁରୀ ନା
Yes,
ସମସ୍ତେ
madam.
ଅଛନ୍ତି
No, one accused is there.
so one accused ତାହେଲେ ପ୍ଲୁରାଲ ସିଙ୍ଗୁଲାର ହେଇଯିବ ସବୁଗୁଡା
Sole accused.
sole accused for issuance of notice to the opposite party by registered post with AD in present correct address para 3 weeks time granted to file the requisites or 4 weeks Mr. Counsel
Malad 4 weeks.
4 weeks because it will come 4 weeks time granted to file the requisites yes next
64.
Mr. Das item 55 you want to say
Yes. Well, in fact,
55 टा उधर लिखी दो काटी दो
I'm grateful, Lord. In item 54, I have got that evidence copy of both the decoy and this shadow witness, my lords. This is a case of trap, my lords. In fact, I will play 55, my lords.
55
It's a criminal CRL pin number 175 for 2012.
since
It will take 10 minutes, 5 minutes.
no actually here the notices were issued earlier and it is only for condonation
Lordship, while disposing that application, Lordship, you can take up this one because they have been declared as hostile. So, with regard to decoy,
let me check the earlier order just a second I'm going to that brief एटा हबनी से the noting is order से आछि final order in MC at flag A regarding condonation of delay so registry is asking the limitation notice was served on was received by Prashant Kumar Sethi instead of Manas Ranjan Sethi for consideration of sufficiency of limitation how can it be cannot be
fresh steps.
তাহলে আপন এটা we can argue for fresh admission যা থিব we may if I am satisfied on merits I'll issue notice again or
I mean, in fact, I am more interested for disposal because the decoy has become declared hostile, and the shadow witness also stated. I got that deposition copy. I have not seen who demanded bribe and what was the demand by the accused.
no the last wherever those matters actually I am finalizing those drafts these are the specific grounds I have rejected the petition if you remember in fact you have argued some 3-4 cases which have been disposed of in all cases chapter pasta because she's the secretary was taken in 5 cases all cases this is the thing the decoy magisterial witness it is sitting by the trial court as magisterial witness or you are calling shadow witness They have not supported the prosecution
The
case.
same case, bro. I mean, because the trap case practical hinges on the
And,
evidence
and, and the other problem is that there is serious discrepancy at times. One is saying that I went to Bhubaneswar, one is saying that I went to Cuttack.
There's a discrepancy.
Maybe memory also fades.
Yes, with the delay in the examination. But this is a case.
CRLLP 175 of 2012. Author Lekhantu. Purana Kative. The learned standing counsel. Mr. Sangram, the standing counsel vigilance for the state. Opposite party blank. Miss case 24 of 2013. Notices after issuance of notice in the miscase for condonation of delay, the acknowledgement due of the limitation notice issued to the sole opposite party has been received as indicated by the registry in the office note by one Sri Prashanta Kumar Sethi. Though the opposite party is Manas Ranjan Sethi. The postal stop. Accordingly, the matter has been put up for acceptance of sufficiency of notice. Acceptance no, regarding sufficiency of notice on the opposite party on the limitation. Para. Since there is no other indication in the postal noting, postal remark, postal remark regarding the how Mr. Manas Ranjan Sethi is relevant. Name of Prashanta Kumar Sethi. How Mr. Prashanta Kumar Sethi is relevant for service of notice. The notice cannot be treated to be sufficient. Apart from the above, upon जो miscase लिख लेंगे ता संगे CRLLP 175 of 2012 कर दियो and कर दियो ता comma देख लिखिए जाम पे लिखिए common order कर देवे. Apart from considering the matter considering the matter where the notices have to be again issued to the opposite party on limitation, this court has the occasion to hear the arguments of the learned standing counsel regarding the grant of leave to appeal. The learned standing counsel strenuously argued that it is a fit case where leave to appeal to be granted, as the learned trial court's judgment suffers from perversity and material irregularity. Para. However, it is fairly stated by the understanding counsel that for grant of leave, the court has to consider the material already on record presented by the prosecution in the trial. And there can't be any further appreciation of any material, or only because certain points have been raised in the grounds seeking leave. Have been raised in the petition. Certain points have been raised in the petition seeking leave. Para. On perusal of the judgment rendered by the learned court dated 28/8/2012, so and so court, pura court nata likhive, in case number so and so, by which the opposite party was acquitted after facing trial for the alleged offences under section 13 into bracket 2 read with 13(1) into bracket small d and 7 Prevention of Corruption Act. Stop. Para. It is indicated that after laying up the trap, the trap has been proved.
That was a successful trap, but in that trap, my lords, the hostile.
It is indicated that the decoy who was supposed to pass on the alleged tainted money to the petitioner, to the opposite party,
Your Lordship, I folded the paper, the evidence of
has turned hostile.
My Lord, in this case, PW4 is the decoy.
Into bracket PW4.
Huh. Lordship, turn to second, the next page is declared, it was examined under section 154.
Yes.
And Lordship, on the last line, I put the pencil mark. He said that he kept the money on the table, but subsequently, I don't know whose table it is. There is no specific evidence that there was a demand. He was there was a specific demand and that was giving to the exact person. Nothing is there.
PW2, PW4 and as well as the PW2.
PW2 also is a overhearing witness.
Was presented as the overhearing witness by the prosecution.
In the cross examination, also can see the, I folded that one.
Para. In view of the above, apart from the thing, out line add karantu, good para add karantu. The learned standing counsel has very fairly presented the evidences of PW2 and PW4 before this for continuation of this court by producing the copies of the depositions.
Certified copies.
Certified copies of the depositions. Having heard the arguments of the learned standing counsel, considering the materials on record, the reasons given in the judgment, and considering the depositions of the PWs 2 and 4 that have been considered in detail by the learned trial court, this court, apart from declining to condone the delay, in its considered opinion, observes that the present case is not fit for grant of leave to appeal. The petition stands disposed of. Yes, since it is already 4:30, no further matter will be called. Only the mentioned matters I will be taking up. Mention order dakantu. को जाएंगे 61 पर 55 64 जाए चल जाता अच्छा then
54 78
नहीं 71
टा मेंशन
71 ना Miss S. Patnaik on behalf of L Mr. Date ही नहीं लगी सिर्फ मिस ही गला Mr. S. Miss M.S. Patnaik on behalf of L. Misra for the petitioner, the learned opposite party blank, the learned counsel for the petitioner seeks accommodation. The prayer for adjournment lekhantu. Prayer for adjournment is made on behalf of the learned counsel for the petitioner due to personal difficulty. As prayed for, list on 16/1/2024. Yes.
78.
Mr. B.R. Mahanti for the petitioner, Mr. Opposite party blank, the learned counsel for the petitioner seeks accommodation to obtain instructions and advance arguments as prayed for list on 29/1/2024. Thank you.